Under complex circumstances, my lord, I am mentioning the tender matters, my lord. The Panchayat Samiti have floated the tender, rejected without assigning any reason, without uploading the contract. Already finalized the tender. My lord knows how it has been done.
Work order has been issued.
No, that's why, my lord, the urgency, my lord.
Very well, file it.
I've already, my lord, yesterday I filed it, supplied the number.
Give notice, Mr. Roy, give
Yes,
notice.
yes. I've already said notice. Yesterday or today I'll mention this matter. After mentioning, my lord, may I mention it is come on Monday so that
Yes, it will appear.
Item
Yes.
number 40, 45 and 61. My lord, 45 is the senior citizen. It is relating to, my lord, mutation. My lord, I have mentioned it, your lordship allowed, but mistakenly it has come under the heading
Unauthorized construction.
Your lordship, but this is not related to unauthorized construction. Item number 45 and 61 is the unauthorized, my lord, mutation. My lord, mutation has been
1 minute, 1 minute.
45 and 60. It has been come under the wrong.
45, Mukul Chandra Shah. This is not unauthorized construction.
Should can it be
All right. In which group should it be placed?
upgraded?
Upgraded motion.
The senior citizen aged about 82 years. 2017, this mutation is kept pending by the Vidhannagar Municipal Court.
Item 45, Pradeep. Today's list, item 45. Place it under the heading upgraded motion.
And
Yes.
61 also, my lord, unauthorized mutation. It should be coming under the upgraded motion, my lord, because it is not related to
61 also upgraded motion.
My lord, may I be permitted to mention one matter, madam? Matter relating to the Ramesh Malik primary recruitment scam, my lord. Upon notice, I am mentioning, your lordship was pleased to direct the board to publish the panel in terms of Rule 8. The order was challenged by the board before the division bench, and the honorable division bench was pleased to direct the board to bring everything on record before your lordship. It should have been the duty of the board to mention the matter, but the board didn't mention.
When is the matter returnable?
30th November matter is fixed, my lord. Every day is important, my lord.
13th means 30th.
30th.
30.
30.
Every day is important.
Not why I am saying so. The panel which should have been published a long ago. Panel has not been published yet. On the last occasion when the matter was taken up by your lordship was pleased to direct the board to publish the panel on 10th. 10th October. They said we cannot publish within 10th October. We need 3 more days. On 13th we shall publish. They went before the honorable division bench. Honorable division bench directed them to. They said that they have already published the panel, though they have not.
Very well. The matter is on 30th. Why do you want it to be preponed?
My lord, on 30th, my lord, every day. Why I'm saying so? Every day is important because there are candidates who are crossing the age limit, my lord. There are candidates.
But then the matter is pending for a long time. Please wait. 30th necessary order will be passed. As the matter is fixed.
The person who is not even eligible to hold the post of Sabhadipati of the district, has been
Sabhadipati of the
district,
district.
Jila Parishad.
Jila Parishad, yes.
He is not a SC, the post is reserved for the SC, Read petition has been filed, this read petition is being threatened, to withdraw this petition. That's the urgency, I was waiting, during this period, he was offered money first. Certificate has been procured. That is my challenge. Now, now every day, he is being threatened.
And did you lodge any complaint before the police?
No.
Why not?
It's not possible for him not to go to the police. Police is within the control of these people.
Yeah, very well. So you can always lodge a complaint through speed post, through regular post, through mail. There are many ways to lodge complaints. Try it out. Where is the matter?
It is in the list 2358.
23. So it will take some time.
235. Kindly fix the date, so that it's going to be taken away. Some protection will be given.
When I'll accept mentioning, please mention at that point of time. Today I'll not upgrade. Yes.
Have the lordship kindly to mention this matter which is already mentioned. Lordship permitted me to approach the coordinate bench having determination. Lordship, I would not require a further release. But my lord, the coordinate benches are of the opinion unless the lordship leaves. So the challenge to the lordship.
Listen, if it is parallel determination, why will the court release this matter? Is it in the list? Matter is there in the list. All right. Which item is this?
446.
This is regarding what?
Panchayat matters, termination of service.
Termination of service. Who is your other side?
Case is there, madam.
Who? The learned counsel you intimate and then mention. We'll see what can be done.
Milord,
Yes.
may I have my lord's kind leave, Milord, to mention two matters, Milord, upon notice. Milord, one is appearing as item number 1296 and the other one is appearing as item number 1677 in the combined monthly list. The one of those two matters, Milord, both the matters pertain to the same unauthorized construction by two different, Milord, plat owners. Now, my lord's pleasure was, Milord, to direct these two matters, Milord, to appear.
Wait.
I'm sorry.
Yes.
Milord, to appear on 29th of November.
Yes.
Now, Milord, there is, Milord, another matter, Milord, which is pending before the learned, Milord, civil court at Alipur, where, Milord, the sanction plan purported sanction plan has been placed, and, Milord, the learned civil court at Alipur, Milord, is destined to pass an order on, Milord, 22nd of this month. Milord, if that happens, then, Milord, possibly this writ petition would become infructuous because they would come and say that the sanction plan has been accepted by the civil court. Milord, this has all, Milord, all of a sudden, Milord, has been, Milord, taken out of the bag and shown to the learned civil court, which is under challenge, Milord, in these two writ petitions.
Let us see what
So,
happens.
Milord, may these two matters, Milord, appear at least, Milord, as to be mentioned on Monday, so that, Milord, we can at least show, Milord, the sanction plan, the way, Milord, the sanction is, Milord, claimed to have been obtained. Milord, there was, Milord, a submission made, Milord, in the order, Milord, which I was trying to, Milord, draw to my Lord's kind attention. Milord, a submission was made by, Milord, this, Milord, person responsible.
29th, you say the matter is there.
29th, the matter is there, but 22nd, Milord, they have upgraded the matter in the civil court and an order, Milord, may be passed there.
Whatever order may be passed, the High Court's order will always prevail.
Whereas to be mentioned on Monday, my
For
Lord,
what reason?
my Lord, will kindly just make that one line observation that, Milord, because of the order passed there, Milord, this matter would not become infructuous. Otherwise, Milord, they will be dangling, Milord, that order, Milord, we are, Milord, really, Milord.
They will be dangling that order where? Over here. This court is here to see how the High Court's order will always prevail over the district judge's orders or lower court's order.
Well, may
Call
this
the
two
list,
matter,
please.
Milord, appear, Milord, fairly at the top on 29th, then. Milord, may I just provide the, Milord, numbers?
Hopefully it will appear.
Really?
Yes.
Great, great.
What is the correction to be made?
Correction is the, my lord, the premises number, my lord.
Premises number?
Lordship.
Let me see
Instead
the.
of 14 by H by 1, my lord. Sir, item 1 almost set. Thank you.
Please come. The matter has appeared in the list at the instance of the learned advocate representing the petitioner for correction of a typographical error which cropped up in the order dated 3rd October 2023. Stop. The premises number mentioned in the second line of the first paragraph of page 1 of the order should read as 14 by H by 1 Chamru Singh Lane in place and instead of 14 by H by 2 Chamru Singh Lane. Stop paragraph. Rest of the order remains unaltered. The department is directed to carry out the necessary correction at once.
Extremely grateful, my lord.
I appear on behalf of the petitioner. In this matter, my lord had been pleased to direct demolition of an unauthorized temple, which was situated on a part of public footpath. An initial order was made, then a group of devotees went up in appeal, directed to file an application, before your lordship. That application was filed. My lord was pleased to deal with it on merits, found that there was no merit in the application, dismissed, that application, and directed the corporation to demolish and bring a compliance report before your lordship. For that purpose, the writ survives. In the meantime, my lord, it appears that the disgruntled devotees have filed an appeal. in that appeal, there is an order directing the state to come and address the Honorable Court of Appeal regarding what its policy is regarding these sorts of temples. And the matter, my lord, has been made returnable. In fact, today, it's appearing today. If your lordship is so pleased, my lord, if your lordship can take up the matter any day next week.
Very well. Please come. It has been submitted by the learned advocate representing the petitioner that an appeal has been carried from the order passed by this court, and the appeal is appearing in the list of the Honorable Division Bench today. Stop. Prayer has been made for adjourning the matter. Stop. On such submission, list on 4th of December.
Obliged, your lordship.
Lordship, in item number 3, Your Lordship, I am appearing for the petitioner.
Yes.
Your Lordship, in this matter, I am being led by senior Mrs. Noel Banerjee, my Lord. I believe she is on her legs, my Lord. I am seeking a short, my Lord, any day convenient, Your Lordship may deem fit, my Lord. Even tomorrow, Your Lordship, if deems fit, my Lord. As may be convenient for Your Lordship's list, my Lord.
May
I am
please, Your
at
Lordship.
Lordship's service.
Lordship, before going into the matter, may I bring to the notice in Lordship attention one document of the Supreme Court. Honorable
No,
Supreme
the
Lordship, yes,
passed by the Supreme Court.
yes, Lordship, this subject property against which they are coming in this writ petition, Lordship,
Yes.
this subject property is in status quo position.
Is
Is in status quo position.
status quo position. Is your microphone working? Please check.
Is working, Lordship.
Yes,
Right.
now it is working. Previously it wasn't.
Right.
Yes.
Sending my apology, Lordship.
Hmm.
Lordship, so this order is passed on October 10, 2022, and till date it is existing, Lordship, the status
Yes.
quo. And Lordship, there previously also filed one writ
I
petition.
am not hearing the matter on merits. There is an prayer for accommodation.
Lordship, the difficulty is they have not been added as a party, Lordship.
Oh, you have not been
No,
added as
we
a
are,
party.
our interest is in this particular property, Lordship. Our interest will be prejudiced if any order will be passed.
Your interest will be prejudiced.
Yes, Lordship.
Who are you?
Lordship, may I, Lordship, hand over?
Yes, yes. Who are you?
I am the decree holder in respect of this property. The petitioners are the association of the occupiers and the subtenants.
All
I have
right.
initiated proceedings, execution proceedings for possession.
All right.
That has gone up till the Honorable Supreme Court. My appeal is pending and there is an order of status quo. On the last occasion also, when the petitioners moved a writ petition against the KMC, but I was allowed to be an intervener. I was a part of that order. In spite of that, my lord, they are not making me a party. I do not know how my right will be affected because I have not been served with a copy of the writ petition. I'm only praying, let me be added as a party. A copy of the writ petition.
Very well. Corporation is ready with instructions.
Primarily, my lord, I have received an instruction. Primarily, my lord, now, my lord, they want regarding the another construction or all other things are there. Therefore, we are in the matter. Now, my lord, they are disputing, my lord, they are trying to, my lord, protect the whatever the actions have been taken by the petitioner, my lord, they are the occupants, and the tenants are now trying to protect. This is the clear.
So this is with regard to unauthorized construction. Is the person who claims to be the intervener responsible for making this unauthorized construction?
They want the right over the property. They are claiming their right. They are claiming that they have obtained a decree. Therefore, they are their right. Therefore,
Yes.
their interest will be affected.
My Lord, one humble submission in this, my Lord, we have prayed inter alia, my Lord, that balance repair works may be constructed because there are certain places, my Lord, because it's an old building, my Lord. So I'm not aware, my Lord, how my learned friends, my Lord, clients' rights may be infringed, my Lord. In any event, if my Lord directs your Lordship, I'm willing
The
to, my
court
Lord.
will not pass any direction. It is for you to decide who to be
I shall-
pleaded as party. Now you have heard the submission of the learned advocate. It is up to you whether to implead or not. If you do not, he can always come up with an application seeking impleadment. Right? So I'll adjourn the matter for this week.
I am deeply obliged.
In the meantime, see if you were added, fine. If not, you know what is to be
Yes,
done.
ma'am. I'll file. I'm grateful.
On the prayer of the learned advocate representing the petitioners, the matter stands adjourned For this week only, or you want some more time?
My lord, 10 days. This week, my lord. Next week, any day is convenient, your lordship.
This week means today, tomorrow it goes.
Of course.
Then it comes up on the next working day.
My lord, Thursday or Friday, my lord.
So you have to make a prayer that you want
Absolutely.
it on such and such date. When do you want it?
Thursday or Friday, your lordship, next week. I'll just
24th next Friday?
24th, your lordship. I'm deeply obliged.
কি বললাম?
छुट्टी नहीं होती सर Friday.
On 24th November.
Deeply.
Deeply obliged.
I beg to appear on behalf of the My lord. At the very outset, my lord, I am seeking, my lord, the leave of this honorable court to file one supplementary affidavit. Nothing is there. On the earlier occasion, lordship was kind enough to
Where
impose.
nothing is there, where? In the writ petition?
No, my lord, nothing is there, my lord, in the supplementary affidavit. What happened, my lord, lordship was kind enough to impose 5,000 rupees cost in the earlier round of litigation. We have duly deposited in the legal service authority. That related papers are there, my lord. That being the situation, that is why supplementary affidavit. My lord, it's a case, my lord, we have purchased this property from Jadavpur University, about 3,000 square feet. Lordship, kindly come to page 31.
1 minute. Is the director of factories represented?
But we have effected service, my lord.
Upon the state?
Yes, my lord. Director factories, director of factories.
Not upon the advocate on record?
Not upon the advocate on record.
Sir.
Because the director of factories, my lord, they are. But in all cases, they are not represented through the, my lord, the state. State is always above. But the thing is this, they are separately, my lord, conducting in so far other matters are concerned. Mr. Ghosh is here. In one matter, his appeal is
I do not
everywhere,
know,
my lord.
let me see.
Director,
that,
my lord, appointed their own lawyer and all these things.
maybe.
Yes.
5 and 6, just give one notice
Lord,
and
Lord,
come back.
Lord.
Please come.
And supplementary may kindly be kept in record.
None appears on behalf of the respondent numbers 5 and 6. Stop. Let copy of the writ petition be served upon the advocate on record, government of West Bengal.
My lord, this supplementary may kindly be kept.
List on 28th November. Stop.
They are 2 week, I have certificate. You know, next week,
Bombay.
Last week of
December. 4th of December. 4th December. And
before that is not possible, my lord. Within 1 or 2 days, we will effect service. Any day, my lord.
No, 1 or 2 days means it comes to the next week.
Next week, my lord.
Right.
Next
week, the learned advocate is required to take instruction. The state advocate have to take instruction. You have to give this much of time. What is the urgency that it cannot
Urgency,
wait
my lord.
before?
This is a question of, my lord, construct. Whether urgency is there or not, that is to be explained by my learned senior.
Yeah.
My lord, that is to be explained by my learned senior. My lord, urgency is there or not. Well, all these things. I have no objection, my lord. Since my learned senior, my lord, is here. If possible, my lord, if possible, subject to lordship.
Mutation and separation.
Lords.
That's a 4th.
I want to make construction over the land.
4th December.
Multi-story.
Learned advocate representing the state respondents shall obtain necessary instruction from the respondent numbers 5 and 6. Let me see what is there in the supplementary.
Kindly see. Yes. That, my lord, direction, my lord.
Supplementary affidavit filed by the petitioner in court today is written with the records.
An affidavit of service also, my lord.
Service taken on record.
Deep law.
Item number 5, I am for the petitioner, my lord. I am proof not today, my lord.
Why?
Because the learned advocate who are appearing in this matter, Partha Sati Dev Burman, my lord, he is not come now. So kindly take it not today, my lord.
Tomorrow.
Tomorrow means Monday, my lord.
Why? Tomorrow means Monday. Tomorrow means tomorrow. Tomorrow does not mean Monday.
Tomorrow is Saturday, my lord.
Yes, so?
So tomorrow is what? Actually, I was not informed, my lord.
On the prayer of the learned advocate representing the petitioner?
Keep it Monday, my lord.
Did you serve?
My lord, I have no any information because I am not the advocate record, my lord. I am only the chamber associate. So our telephone informed me that Parthasarthi Devarman will not come today. If he come lately, so you take time and fix the matter on Monday.
The matter stands adjourned for this week. Stop. List on 4th December.
But I appear on behalf of the petitioner. Let a minutes pass over, my lord. My file has not come, my lord. That's what I'm
The file has not come.
Just a minute.
Passover is not possible. In that
Lord,
case,
I'll
not
proceed.
today.
I'll just proceed then. My lord,
Or I can adjourn it for the day.
my lord, all the three matters will be adjourned in that event.
So if it is adjourned, where is the difficulty? Only for one day. You do not have the papers with you.
My lord, I'll just proceed with it, my lord. I'll proceed with it, my lord.
Yes.
My lord, the challenge in this writ petition is that whether after invocation of the provisions of section 401, whether immediately they can proceed and change to 408 or not. This issue
401
was
means the stop work or 400?
stop work.
Stop work.
Now,
401.
my lord, immediately after proceeding, giving us the notice under 401,
Hmm.
my lord, we wrote a letter that kindly give us an opportunity of hearing. That letter has been received by them. They say that they don't do anything. They come all of a sudden and demolish. I must be candid.
Demolish.
A portion. I must be
Portion.
candid before your lordship, my lord. There is a dispute as regards to the sanction plan is concerned.
All right.
Now, my lord, kindly, my lord, takes up page 103 of your lordship's brief, my lord.
Yes.
Kindly see, my lord, this is the notice under 401.
Yes.
Kindly see the date. It is 12/6/2023.
Hmm.
Now, my lord, kindly takes up the next page. This is a representation which has been given by us. They receive the representation. My lord, what is the, my lord, the usual as per the law, my lord, after issuing a notice under 401, my lord, 40 subsection 1 proceeding is to be initiated against me. Hearing is to be granted.
Not necessarily. If
My lord,
there is any
maybe.
emergency.
My lord, the emergency, if at all, my lord, presumingly if there is an emergency, that emergency ought to have arisen on 12th of June. It is not that it has developed in these 3 months.
Maybe it has developed in the 3 months.
There
You
is a
have
stop work
continued with
notice,
the
my lord.
construction.
There is a stop work notice, my lord. Then they must come up with this, that I have, by violating this, I am proceeding with the construction. Now, my lord, that was the report they were supposed to produce today, that whether after 12th of June I have raised any construction or not. Now, my lord, if at all there is no such construction, my lord, your lordship on a separate matter which is presently under challenge but not been granted any stay till date, your lordship has said the emergent condition under section 408 has to be dealt on the basis of the situation, whether at all any construction was raised on after the receipt of that notice or not. That is the, my lord, thing which is to be decided. Judgment gulo de.
My lord, Mr. Naik is for the KMC, my lord. I am not briefed in this matter. Kindly give me, my lord, short Passover.
Passover, it is not possible.
He's in before courtroom number 29, my lord.
So he must be assisted by somebody. Who is assisting
Yes, my
him?
lord, somebody is assisted by him, but I think he is not, my lord, in prison, my lord. He's in before, maybe in any other court, my lord.
And the instruction is not also with you. I need the instruction. I need not require anything else.
Just give me a 5 minutes Passover. I just talk with Mr. Naik with that.
5 minutes, the court cannot keep waiting.
Yes, my lord, I know, my lord.
I'll make it not today in that case. Please come. On the ground of unavailability of the learned advocate representing the corporation, the matter stands urgent for the day.
My lord, I appear on behalf of the petitioner.
1 minute. Who is for the corporation? Yes. Is it the same thing?
It is not the same thing, my lord. Here I have a better foundation. I have a plan.
Yes. So what is the challenge?
The challenge is, my lord, kindly, my lord, takes up The
Page
notice
48, 401 notice.
47 kindly takes up.
47. Yes.
3A and 3B is mentioned. Kindly see the premises number. 3A and 3B is being carried on in
47.
deviation.
1 minute. 47 is serial number such and such approved by such and such.
It is. My lord, that is 46 probably, of your lordship. This
46, the
approval, your
voted-
lordship is.
This is 47.
This is the sanction approval. Kindly, my lord, takes the next page. Probably my numbering is wrong. My lord. Kindly takes the next page, an extra P4.
Is it the 401 notice that you are
Yes,
reading?
yes.
Hmm.
Kindly see the premises number, my lord. 3A and 3B. Admittedly, the petitioner has purchased a property in respect of 3B. I have a valid agreement to that effect. The deed of conveyance is there. I was conducting a repair work at my premises with their approval. Now their approval, your lordship has seen that. They come and suddenly serve us a notice by saying that 3 and 3B are not construction is being carried out in deviation. Now, while at 3A and 3B, I kindly takes up the recital of my deed. It was partitioned as long back. Kindly takes up the page, my lord. Probably that will be lordship's page 17 or 16, my lord. There's a confusion, my lord, in the page number, my lord.
Yes.
The recital first paragraph, my lord.
Hmm.
Whereas by a deed of partition dated 13th of February 1992 by deed number such and such made between such and such, jointly referred as first part therein, and Shima Dev Dipti Bhattacharya jointly referred as second part therein, wherein a joint property being two-storied brick-built dwelling house together with such and such at premises number 3, Shitikanto Banerjee Lane. At that point of time, my lord, it was 3. Was partitioned amongst them an equal share measuring about 1 kathas 3 chotaks 27 square feet with building was allotted to this said Bijanbala Mukherjee, Pranab Mukherjee, Ashish Kumar Mukherjee, Amarjyoti Mukherjee, and Shapon Mukherjee. I pause over for a moment. Kindly takes up the previous page once. From whom I have purchased? I have purchased from the legal heir of Shapon Kumar Mukherjee. Kindly see the name Rajiv Mukherjee. Then they comes and say Shapon Kumar Mukherjee. His father's name is late Shapon Kumar Mukherjee, who is the owner of the property. Now, let kindly takes up the next paragraph. And whereas in the manner aforesaid, the said Bijanbala, Pranab Mukherjee, Ashish Kumar Mukherjee, Amarjyoti Mukherjee, Shapon Mukherjee, and Shubhra Goswami became joint owners, seized and possessed of, and otherwise well and sufficiently entitled to the said two brick-built dwelling house together with underneath measuring about 1 kathas 3 chitaks at premises number 3, such and such, and mutated their names in the name of record as joint owner, and since then the same is known as premises number 3B. Now, whether the construction, what deviation they are speaking about, in which portion they are speaking about, this order is not clear at all. Now, kindly takes up my plan which they have sanctioned, my lord. This approval was made on 28th of February 2023 and valid till 2025. So they cannot say that with my repairing works was going on without any sanction. Now, they issue a notice by saying 3A and 3B. Now, let them tell me that whether I have made any deviation.
No, that is what page 48 says.
Kindly
that
see.
3A, 3B.
3A and 3B.
Carried on.
Carried on.
In deviation from the sanctioned and approved
yes.
plan.
Now, that 3A and 3B. 3A does not belong to me.
Very well. 3B.
I am in part of 3B.
3B.
That is, kindly see, that is, if that ought to have been the situation, then the notice would have been issued in my name. Kindly see the names. It is not only my name. There are several other names.
You are?
I am only Bappa Das.
Bappa Das. Yes, the others are also there.
Yes.
Shima, Dipti, and...
Now, they are the owners of 3A. Now, maybe they are raising construction in 3A. Whether they have taken an inspection.
My lord, 3 and 3B. My lord, one is vacant, actually extension or the construction is upon the both premises. I have the report. And my lord, 3B, that is the reconstruction plan. And he actually demolished everything and thereafter constructed, and that is 3 and 3B covered. So we actually stop work just prior to Puja vacation, prior to Puja.
3A is vacant.
one portion, they are actually constructing 3B, that is reconstruction plan.
Yes.
They are actually demolished everything and thereafter construction was raised. That is
Can this be
specific.
done in a reconstruction plan?
Reconstruction plan, that cannot be done.
That cannot
And
be
that
done.
is the unauthorized construction entirely. So just prior to puja, so we stop work. He challenged the stop work notice, that is without any
And
specification.
tell me, 3A also construction is going on together.
Certain portion of the 3A, that's why the name of the others came.
Certain
Portion of the
3A is
3A, which
also
was
going on.
vacant, that is my instruction, that is actually very clearly stated there in my report.
Oh, expected devices number 3B. Did you intimate the petitioners the deviations that are going on?
My lord, thereafter what happened, my lord, today is the first day after vacation. That is that instruction I don't have. That is the 18th October.
Yes,
report.
This is 18th October.
And thereafter, my lord, I am. Because I am not here, the official is not here also. My lord, that is the only thing corporation can do when some unauthorized construction is going on 401. Everybody knows.
Please come.
And thereafter, the consequential step 400 subsection 1 or 8.
Written inspection.
That is with the authority, my lord.
The petitioner claims to be the owner of the premises number 3B.
Well, not the entire premises.
Portion of 3B.
Portion of 3B. I have annexed the deed also.
Claims to be the owner of a portion of premises number 3B, Shitakanto Banerjee Lane, Ward number 8, Borough 1, Kolkata Municipal Corporation. Stop. The petitioner is aggrieved by the notice issued under section 401 of the KMC Act, 1980 on 16th October 2023, addressed to the petitioner and other persons, describing them as persons responsible for making construction. Construction in deviation of the sanctioned or approved plan in respect of premises number 3A and 3B. Stop. Paragraph. Specific case of the petitioner is that he is no way related to premises number 3B.
Well, 3A.
Oh, 3A, and accordingly, the impugned notice is liable to be set aside. Stop. It has been submitted that construction may be carried out by the carried out at premises number 3A, but the petitioner is no way responsible for making such construction. Stop. Paragraph. It has been submitted that a reconstruction plan was approved by the Kolkata Municipal Corporation on 28th of February 2023, and the same is valid till February 2025. Stop. The petitioner is carrying on construction strictly in accordance with the approved plan. Paragraph. Learned advocate representing the Kolkata Municipal Corporation has received instruction from the assistant engineer within brackets civil / building / borough 1, wherein it has been mentioned that on inspection of premises number 3B, it was found that construction with addition and alteration of 3-storied building is going on in deviation from the approved reconstruction plan by demolishing all the existing structure. Stop. Moreover, construction of RCC slab at first and second floor roof level, supported by brick wall, is going on in a portion of premises number 3A, which is adjoining and adjacent with the premises number 3B. Stop. Paragraph. To stop further progress of unauthorized construction, notice under section 401 of the Act has been issued upon the persons responsible with intimation to Shampukur police station. Stop. The matter is under process of section 400 of the Act. Stop. Next. Learned advocate for the petitioner submits that no inspection was conducted prior to issuance of the impugned notice under section 401. Stop. The petitioner has not been intimated with regard to the details of the alleged deviation. Stop. Paragraph.
My lord, details are there. I'm extremely sorry to interrupt. My lord, page 45, that is the demolition sketch plan. That is actually here.
Stopped.
My lord, that is the
This is the plan which was
my lord,
given
that
to
is-
us.
that
That
is the-
cannot
my
be a
lord, your
demolition
lordship,
sketch,
kindly
ma'am.
see.
Kindly see.
That is your lordship, page
Kindly see this
45.
one. This one is being said by.
Page
Let
45.
me submit, my lord.
Page 45 is something else in my brief.
Page
My lord,
44 that
just previous, because my 45, that is the demolition sketch plan. That is earmarked there. What is
1
the
minute, 1 minute.
lordship?
Page 40, 41, 42,
My list parties copy previous page.
43.
Well, this one will probably what is being referred to. This one is a demolition sketch, ma'am.
That is there.
Yes,
This I cannot find in my brief.
that is there. Kindly see
That
page.
is there. That is
Kindly
there.
read both the. My lord,
In the
last
read
page of
petition,
the-
that is there.
Annexure.
Annexure
Well, kindly
P3.
take this.
Annexure P3.
1 minute, P3. Reconstruction.
The last page is the notice under 401. The previous page, what Mr. Das is speaking about.
My lord, what I am speaking about, only 140 square feet flat
Yes.
purchased, illegal purchase, and the
Illegal purchase.
three-story or two-story building are going on. So we actually stop our notice is there. What is the
Please
scope?
check if that document is here. Ekটু দেখান তো। Yes, that is the approved plan.
That
you
is what
say.
he's saying is a demolition sketch, ma'am.
That is demolition.
Very good submission, my lord.
That is
That is a very good submission of
My
Mr.
lord, that is no, my lord. That is my lord. I can
Kindly, my lord,
explain
record this submission.
what I submit. I can support this.
Kindly,
Your
record
lordship,
this.
kindly take this page.
Hmm.
My lord, that is the earmark. That is my lord proposed, and my lord existing. That is there. And what is this line?
No, 1 minute. This page, it says at the top right side, plan proposal of reconstruction work.
Reconstruction work group under section such and such.
Yes.
My lord, what I am.
So where is the demolition sketch?
My lord, what I am submitting, my lord, that is the entire structure. That is the indication of, that is the red mark, that is original. I can produce it. Your lordship, keep this.
No, you forward it to the petitioner. What will the court do seeing the demolition sketch?
My lord, what happened, my lord?
1 minute.
In the second
Please wait.
floor, your lordship.
Madam, right. And the learned advocate appearing for the corporation submits that the petitioner has been made aware of the deviations. Stop. A demolition sketch was also prepared, and the petitioner has been made aware of the same. Stop. Next. Paragraph. From the documents annexed to the writ petition, there is no evidence to show that the demolition sketch or the details of the unauthorized construction was forwarded to the petitioner. Stop. Next. Paragraph. In view of the above, the executive engineer of the concerned borough is directed to cause a spot inspection upon prior notice to all the necessary parties to ascertain the exact nature and extent of the unauthorized construction and intimate the same to the persons responsible for making construction. Stop. Next. The spot inspection shall be conducted at the earliest, but positively within a fortnight from the date of communication of this order, and details to be intimated. Details of unauthorized construction to be intimated to the petitioner within a fortnight thereafter. Stop. An opportunity of hearing shall be given to the necessary parties. The writ petition stands disposed of.
Well, the only difficulty is this. May I have deepest respect, Well, the difficulty is we, the corporation, detect a two-story building that is reconstruction in the guise of
Are you objecting to the hearing?
for hearing. That is the 1 and 8 that should be with us because the other factors are there. We can inspect the premises and thereafter
hearing and line
we'll take the necessary steps as per law.
Last যেখানে বললাম hearing. Stop. লাইনটা কেটে দিন, অপরচুনিটি অফ হিয়ারিং লাইনটা কাটুন, ওখানে লিখুন যে the concerned officer of the Kolkata Municipal Corporation shall take steps in the matter to deal with the unauthorized construction in accordance with law.
I am grateful to you.
Service taken on record at the instruction forwarded by the concerned officer of the Kolkata Municipal Corporation, signed on 18th October 2023, be written with the records.
Okay.
Yes.
Well, I beg to appear on behalf of the petitioner. Well, initially a writ petition was filed, my lord, which is at page, your lordship directed that prima facie there was a detection of an unauthorized construction, my lord. Your lordship directed the corporation to grant an opportunity of hearing and to pass a rescind order. Kindly takes up page 22 of your lordship's brief, my lord.
22.
22 is the order.
Yes.
Kindly takes up page 23, last paragraph, as the department has already come.
December 2022.
Yes.
All
As-
right.
As the department has already come to a prima facie finding that construction has been made illegally and in an unauthorized manner, accordingly, the respondent number 5, being such and such, is directed to take necessary steps for demolition of the unauthorized construction in accordance with law after giving an opportunity of hearing.
Yes. Then.
This was the order of your lordship. Kindly takes up page 25.
Yes.
This was the order passed by the executive engineer.
Hmm.
Page 26 is the operative part, my lord.
Yes.
Unauthorized construction detected.
Right. Then.
Kindly takes page 27. The same was forwarded to the respective parties also.
Yes.
Now, my lord, the next order.
Appeal preferred, building tribunal.
No, my lord, kindly takes page 37 first. Thereafter, I'll take you to the building tribunal's order. My lord, we again came up before your lordship, my lord, when the
Yes.
private respondents intimated that they have filed a BT appeal. Kindly see the third paragraph, your lordship has recorded BT appeal now. Now, my lord, takes up the second page, the last page 38. Your lordship said that in the event they obtain stay within 13/10/2023,
Yes.
the KMC will be restricted, otherwise the order will be implemented. Now, my lord, I'll take your lordship to the BD tribunal's order. My lord, admittedly, I must submit one thing, my lord. Today, as on date, my lord, this order of your lordship has been challenged. This order dated 21st of June is under challenge. And I have annexed that order also, my lord, page 31 of your lordship's brief, my lord.
Yes.
They have challenged the order. And
16th of November.
no, my lord,
was due to
19th
appear.
of October 2023, page 31.
Hmm.
That is what has been under challenge. But no stay as on date has been granted, my lord. I must show this to your lordship, my lord. Now, my lord, kindly takes up the BT Tribunal's last order, which is at page 30.
Hmm.
They are repeatedly not appearing there. So that's why today is fixed for show cause. Learned advocate for KMC is present. Learned advocate for appellant is, if I may say, my lord, absent. An adjournment petition, let it be kept with the record. Next date fixed on 8/1. So, my lord,
So your counsel was absent, or
no, no,
whoever
no.
the
I
appellant?
am not the appellant. The appellant is the private respondent.
All right. Is there a private respondent?
Yes,
here
I have
also?
served them.
What is the role of the private respondent? Is he the complainant?
They are the person responsible. I am the complainant.
You want demolition?
Yes.
All right.
Well, that's why we have preferred this writ petition for implementation of the early order of the executive engineer, which shows for demolition, my lord. Because they are not appearing before the tribunal, neither are they proceeding anywhere. And your lordship's order was till 13/10. They have failed to obtain any order of stay, my lord. And kindly see,
What
my lord,
happened to the appeal? Yesterday it was not taken up.
no, my lord, because their lordships did not sit yesterday. It is today. It is in today's list. If your lordship adjourns it,
I'll adjourn it.
yes.
Please come.
But I filed the service, my lord.
Learned advocate representing the petitioner submits. No, not submits. Draws attention of the court to the order passed by the Honorable Division Bench on 21st June 2020. Order passed by the Honorable Division Bench on
19th of October, my lord.
13th October.
My lord, 19th October. Page 31, my lord.
19th October 2023, passed in APOT 396/2023. Stop. The appeal is pending consideration before the Honorable Division Bench and is appearing in the list of the Honorable Division Bench. Stop. Next. In view of the above, list the writ petition on 4th of December. What about the service upon the private respondents? Did they receive?
Yes.
They have received it. Affidavit of service filed in court is taken on record. None represents the private respondents.
But initially, it was filed before the vacation bench, my lord. So it was adjourned and today it is appearing.
My lord, I appear for the petitioner.
Yes.
My lord, this is in respect of the charges which are to be paid for deviation in the plan. My lord, because of certain necessities, a deviation from the sanction plan was made in the construction. Proceedings were started by the respondent corporation. It was found that these changes were necessary, and therefore, by payment of penalty, the deviations were regularized. Now, the only dispute is the rate which should be applied. The reason is, Lordship, this order permitting the deviation was passed on 4th January 2021. In the order, it was stated that the entire process of determining the fees and my deposit should happen within a period of 30 days from the date of the order. So 30 days from 4th January 2021. However, no determination of the fees was made. No demand notice was issued to me for me to make the payment. They waited for more than 1.5 years. In fact, more than that, 1 year, 9 months. And finally, in 24th August 2022, they issued a demand notice, but applying the schedule of charges as applicable for 2022 and 2023. In our case, Lordship, it should have been 2021, 2020, 2021. They waited for 1 year, 8 months, and thereafter, in the meantime, the charges had increased. Then they imposed the increased charges on me. So I challenged that demand notice. before your lordship on the ground that I am liable to make payment as per the rates of charges as existing on 4th January 2021, because that is the date on which the order was passed, and the order envisaged the entire process to be completed within 30 days therefrom. That was not done. Therefore, the delay was entirely on the part of the respondent corporation. The argument is that the respondent corporation could not have themselves sat on the matter so that the charges would increase and new schedule of charges would come post March 2021. Again, it increased from March 2022, and then they imposed those charges on me by the demand notice of 24th August 2022. That was the ground of challenge. An interim order was passed by Lordship to make a certain deposit. We made our internal calculation as to what should be the charges if we are to apply the 2020-2021 rate. We had preferred an appeal from my lord's order that the amount was varied before the Honorable Division Bench, and it was remanded back to your lordship to hear the matter on this point, because this is really speaking the only point involved. Now, the respondent corporation has not filed any affidavit to put its stand on record. Well, to be very fair, I will not stand in the way if the respondent wants to file an affidavit so that the matter can be heard. If they do not want to file an affidavit, lordship, I'll proceed and lordship can dispose of the matter.
In view of the order of the division bench, the only thing to be considered in this present petition, because he has stated that the rate of 2021 to be applied. Then the matter went before the division bench, and there the court considered three situations, and the court considered and passed an order.
division bench order
This court said, my lord, which of the schedule of rates to be applied, 2021, 2020, 21, 22, or 22, 23. These are for these particular reasons, my lord, matter has been sent back to a losses court. Therefore, it is to be considered whether, my lord, which year the schedule to be applied. The calculation and other things are different situation, my lord. That is not the issue here. Here, the issue is, my lord, which rate to be applied. Therefore, if your lordship comes to a conclusion, this particular year's rate to be applied, then, my lord, even, my lord, I may say that 22, the communication which has been made, that may not be the correct, my lord, figure. It may, my lord, the 2021, 22 apply, rate to be applied. That depends on certain facts which are on record. That record, my lord, my learned friend has not, my lord, stated in detail, my lord, only, my lord, he is saying about the order of the special officer building, which was not even communicated to them when they have annexed it here.
Do you intend to file an affidavit or
I
not?
can, my lord, instead of filing, because this is the issue only, I can, my lord, submit a short report to your lordship's court, because instead of, my lord, going into it, because other things are not necessary.
Report by way of affidavit?
By report, I can, my lord, submit, my lord, to this extent that, my lord, which rate, my lord, what are the facts on record? Facts on record which have been suppressed by them, and, my lord, which rate to be applied. That, my lord, report, my lord, I can submit. Because I can show, my lord, on production of the documents before the lordship's court, because, my lord, these order, if you can once, my lord, you can just, my lord, see the order.
Order of?
The special officer building.
That
At page 46. The major deviations have been allowed, but I do not, my lord, dispute, my lord, when my authority has taken that decision. You can come to, my lord, page 46. My lord, got it? Also, you can see, my lord, the deviations are required and provided.
No, tell me one thing.
But I'm submitting to your lordship.
Sir, you intend to file an opposition or report or something, relying upon which the writ petition can be disposed of.
Well, I can submit report, my lord, but prima facie, I can show to your lordship, my lord, this can see, my lord, my lord,
not showing. You keep something on record because the matter is surely supposed to travel up. So the division bench or
but in the meantime, what has happened, that order should not have been given effect to. My landlord is acting on this order. He is, my lord, using the property.
I do not know.
But he is using the property commercially. Because this, my lord, they allow, is a residential building. It has been allowed to be, my lord, the change of use. But instead of making that payment, my lord, he is, my lord, I can say, my lord, he can dispute about the payment part. But at the same time, he cannot my lord, act on that. He cannot my lord, use the property.
It is always open for you for taking steps against any
Your
person
lordship, make it
who
clear, my lord, because my lord, he cannot my lord, act on this my lord, order.
make clear what?
Because my lord, I can my lord, take appropriate steps in the matter because
My lord,
he is at the
listen.
same time he cannot.
Why do you require this blessing from the court? Nobody has stayed your hands.
Very good, my lord. I'll
This
stop
matter
because he
is
cannot use the property commercially
Lordship,
up
I
to you
without
to
without
take
my lord, complying
steps.
with the provisions of the act.
Here the issue is only which rate to be applied, whether 21 or 22 or 23.
21, 21, 2021, 21, 22 or 22, 23, the financial years.
Whatever the rate is.
These are the.
If there is anything beyond or over and above whatever is there in the writ petition, you can always take steps. Nobody is stopping you. And why do you require an order from the court?
But I'm submitting to your lordship, my lord, sometimes it is happening, the matter is before the court on the issue of the charges to be paid. But at the same time, when the
Retention
charges,
charges and the change of user are something two different
but
things.
subject to certain things, the order to be applied or given effect to subject to certain things. When these issues are not settled, then he cannot act on that. He
My
cannot
lord,
take the benefit of this order.
My lord, may I make a submission, my lord? This is perhaps a completely incorrect submission for the simple reason I am not challenging the order of 4th January 2021.
He's not challenging,
My
but
lord,
it is
my lord,
subject
may
to certain thing.
My lord, may I make my
When
point,
that's-
my lord?
that
My
all
lord, may I
these
make my point?
conditions, my lord, is
It's
in dispute.
My lord, I've made a deposit before court. In fact,
is
he
the- that is
cannot
the
take steps.
dispute.
If my learned friend tries to take any step now, it will be contempt of court. My learned friend perhaps has not read the order passed by your lordship as also the division.
I have seen the order. You have been asked to pay deposit, but at the same time you have not given that liberty. That subject to conditions have not been fulfilled, and at the same time you will be continuing to use it as it is commercially. He is merely enjoying the property.
My lord, that I'm
Okay,
entitled
commercial
to. I've
is a
made the
residential
deposit.
building.
My lord,
You have been
the
getting
amount,
benefits
an
subject to
amount
that.
has been fixed by the honorable
Then
division bench. I have
dispute.
made that deposit. I have
No,
made the
conditions
deposit.
for
My lord, what is this?
condition
Is a
has not been
completely
settled
perverse
finally.
submission. My lord, kindly
Conditions have
reads
not
the
been
order.
settled.
There's a stay on the demand notice.
30 lakh has been deposited.
Lordship, it has been.
And according to the 2021 calculation, it is 41.27 lakh.
No, 2021, not that much. It's above 50 lakhs.
No, it is recorded in the order I see, division bench's order, that the financial year of 2021, if the rate is taken, then it will come to 41.27, out of which 30 has
But
been
that is
deposited.
their contention possibly, madam. Because we submitted the chart before the court. Calculation.
My lord, the exact quantum,
3 lakhs, according to us, 53 lakhs, if it is well 2021.
my lord, the honorable division
Lordship,
bench
on
has accepted
on
a
consideration of
certain.
that, your lordship.
53, I can see.
Yes, madam. Your
My lord,
lordship,
that
on
is-
consideration of that, directed madam 40 lakhs to be paid. They went before the court. Then the court madam deduced certain amount. But I'm on the point that it is not allowed the special officer building pass the order subject to certain conditions. Conditions, the issue is still the open for consideration by the court.
No, it
Therefore,
is
he
not,
cannot.
lordship. It is
Why not?
absolutely not, because no one has challenged the order of regularization. We are only challenging the
Because
demand notice,
No, that
applying a
demand,
wrong
madam,
rate.
that is
My lord, this,
subject to
my
certain
lord, may I,
conditions.
this is absolute.
This
I
is
have
subject
nothing to
certain
say, lordship.
conditions.
I have
You are
nothing
not-
to say.
You are not complying with the conditions.
I am complying with all
because
conditions
there
of
is a
the order.
dispute.
I have
dispute
complied
is
with
to be
all
resolved.
conditions of the 4th January order. That is not even in
Do
dispute.
you intend to file anything, or I can see a calculation over here?
But your lordship need not look into the calculation part, because your lordship only the almost single division bench has requested which year to be applied.
Which year to be applied?
This is the issue. Therefore, calculation part,
Well, according to the petitioner, since the order was passed in 2021,
I will
it
just
is
on the
28.
point I'll show that it's not on 21, because this order where from they have got it, this order. I have not communicated the order. This is where in the
There
website.
are all these things on record. Will you not say that this order was not communicated?
Very good, I'll
The petitioner collected it from somewhere.
report in the form of ABT. Because he is completely misguiding your lordship. Because subsequently,
are required to bring the things on
I know.
record, which according to you,
I
the petitioner is suppressing, or which the petitioner is trying to use for misguiding the court,
my lord.
according to you. So without those documents, how can
Very
the
good,
court
my lord,
decide?
because my lord, I thought, my lord, that on the face of these certain documents, my lord, I can show to your lordship that which, my lord, the years yet to be applied. But yeah, even, my lord, your lordship, my lord, it may be good, my lord, to have, if something, my lord, brings on record.
Yes.
Right.
Please come. The issue to be decided in the present writ petition is the rate which is to be applied for imposing
allowing
the retention charges.
Retention, for allowing retention of the unauthorized construction and change of use.
Both.
Both.
Change
That
of
is
use,
that-
is it there?
Yes, it's a residential building allowed to be commercially. That is I'm submitting. They are starting, my lord, using for commercial use.
ওটা হচ্ছে, for imposing the retention charges of the unauthorized construction and change of use of the
Sanction use, change of sanction use.
change of sanctioned use of the premises. Stop. Next. The corporation is directed to file a report by way of affidavit. How soon? The sooner you do, the better for you.
That's right, my lord. But 1 week I have some difficulty. In the first week of December, you'll see.
Very well. By 8th of December 2023. Reply, if any. By
My lord, 1 week thereafter, lordship.
15th.
15th, lordship.
List on 19th of December for hearing.
Grateful, my lord.
Yes, my lord, they have complied with the order. My lord, new appointment letter has been issued according to the last order. To find out
already joined, my lord.
he have already joined. I have
this joining report.
joining report. I have also given.
Please come.
My lord, one thing I should mention that they can do it earlier 4 months ago because the order of the court was that 15th 15th June. 15th June that they have taken adjournment only for fortnight that they will issue the appointment letter. 15th June, my lord, kindly see order dated. Second paragraph, adjournment for fortnight. They have prayed. But after 4 months.
How much salary do you receive? How much salary do you receive?
Now the basic says 24,700 and it will be added.
24,000?
According to appointment letter, my lord. It is in the appointment letter. I have given the copy. 24,700 non-trained posted in school. In the first paragraph. Appointment letter, first paragraph, my lord. and something will be added.
Learned advocate representing the petitioner submits that appointment letter has been issued in favor of the petitioner on 2nd November 2023, and the petitioner has joined service on 8th November 2023. Stop. According to the petitioner, there has been delay. There has been enough delay in complying the court's order, for which the petitioner had to suffer pecuniary loss. Stop. Next. It appears from the documents placed before this court, and upon hearing the submissions made on behalf of the parties, that indeed there is delayed compliance of the court's order. Stop. Next. Now, for the purpose of consideration of imposition of penalty on account of delayed compliance of the court's direction, the alleged contemner will be at liberty to file affidavit disclosing his stand by a fortnight. List on 7th December. Now make it 14th of December 2023 under the heading contempt application.
Earlier occasion, my lord, the council, my lord, has issued appointment letter. Your lordship specific observation was that
Letter of appointment and the joining report be written with the records.
Yes, my lord.
There has been delayed compliance for whoever part it is.
Yes, my lord. If there is any
issued in his favor,
scope of reply, my lord.
Going through that, there is a specific, my lord, school nearby.
For imposing punishment, what reply will you give? It is between the court and the contemner. Let us see what punishment can be imposed. Next one, please.
To your lordship, I am for the petitioner.
Order complied?
Your lordship, one order they have passed, but as my understand, the order has not been complied. Kindly see.
Not complied.
If your lordship kindly come to my contempt application at page 13.
Contempt application, page 13.
The order passed by your lordship on 7th of September 2022.
Right.
Kindly come to the page 15 of the order dated 7th of September 2022. There are two portions of this order. One, first part is the writ petition is accordingly disposed of by directing the respondent number 10, being the Executive Engineer Civil Borough 13 Committee, Kolkata Municipal Corporation, to consider and dispose of the writ petition representation made by the petitioner strictly in accordance with law, after giving an opportunity of hearing to all the necessary parties, including the petitioner, within a period of 3 months from the date of communication of a copy of this order. The said respondent shall pass a written order and communicate the same to all the necessary parties, including the petitioner, immediately thereafter. The next portion of the order is, in the event the aforesaid respondent is of the considered opinion that the construction has been made either in violation of the plan sanctioned or devoid the sanction plan, then necessary steps shall be taken to deal with such unauthorized construction in accordance with law. Two portions are there. If your lordship kindly come the next page, page 17, the learned advocate for the petitioner has communicated the order on 17th of September 2022. no step to consider. Then another representation has been given on 21st of October 2022 at page 20. No steps. The contempt notice was served at page 24. And
what is your submission? Tell
my
me.
submission is, your lordship, kindly come to the order which was passed in 4th of August 2023.
Yes.
Kindly see first two line, your lordship.
Hmm.
In terms of the order of the Honorable High Court, Calcutta, dated such and such, in writ petition number such and such, hearing is taken place. Hearing was taken and concluded on 22nd of July 2023 in presence of petitioner, respondent, and their respective advocates. Then hearing was taken place, your lordship. Kindly come to the page number 2 of this order.
Yes.
Kindly see the second last paragraph. In hearing of the officials of the building department, submit that building department inspect the case premises to look into the illegalities as appended with the question premises. From the site inspection, it was revealed that private respondent such as such has constructed a single-storied building in deviation of the sanction plan of two-storied building. Next paragraph, on the basis of the report put up by the sub-assistant engineer and assistant engineer civil executive engineer building, advised to deal the case under section such and such on 4th of August 2022. Kindly see the date, your lordship. And subsequently notice under section such and such was served upon the private respondent. The entire matter was placed before the special officer building for hearing. At that point of time, hearing, not for the consider of the representation dated 23rd of June 2022.
What was your representation about?
Your lordship, if your lordship kindly come to the
Tell me, what was your representation about?
Yes, I am coming to that.
Your allegation was about unauthorized construction?
Yes. But kindly come to page 3, your lordship, kindly come. A hearing on 20th of September 2022.
Yes.
And it is reflected from the attendance sheet before the special officer that petitioner Arup Rai Chaudhuri was present at the time of hearing. The hearing notice has been given to the petitioner that I have the hearing. This is the hearing notice. At that point of time, this hearing notice was given, but not to consider the representation of the petitioner dated 23rd of June 2022. Now, your lordship, they have stated in this next paragraph, finally, the special officer passed an order on 2nd of November 2022, retaining the single-storied building which was constructed in deviation from the building plan. Later on, kindly see, later on the order of special officer was passed in MIC resolution such and such, dated 29th of May 2023. The private respondent already paid the retention fees amounting the other necessary formalities. Kindly see the last line under the above pros and cons. After meticulous examination of the statement, written submission of the parties during hearing, the undersigned is following views. Kindly see the fourth point. There is hardly any scope to allow the prayer of the applicant Arup Rai Chaudhuri as enumerated in the representation dated 23rd of June 2022.
So according to you, you are aggrieved by this order?
Yes, I am.
It's gone into in the contempt application.
No, I am aggrieved by this order. I know, your lordship, but the order which has passed in the first hearing was taken place on 20th of September 2022. Not for consideration of my representation, but to consider of my representation and to comply with the order of your lordship's order. The hearing was taken place on 22nd of July 2023, your lordship, after more than after 1 year.
So there has been delayed compliance.
Yes, your lordship.
This is the only issue that you say.
Yes.
But there is no pecuniary loss, or you did not lose anything, or you were not prejudiced in any manner, because it appears that the according to you, the alleged unauthorized construction was regularized by
Yes.
accepting the retention charges.
And when it has been regularized, after filing the contempt application and without consideration my representation.
Very well. Please come. Order dated 4th August 2023, passed by the executive engineer within bracket civil / Borough XIII. Kolkata Municipal Corporation has been produced before this court. Stop. It appears therefrom that there has been delayed compliance of the order dated 4th August 2023. No. There has been delayed compliance of the order passed by this court on 7th September 2023. 2022. 7th September 2022. Stop. Next. The petitioner is aggrieved by the manner in which the order of the court has been complied with. Stop. It has been submitted that without considering the representation filed by the petitioner, the special officer within bracket building allowed retention of the unauthorized construction upon payment of retention fees. Stop. Next. The petitioner is aggrieved by the manner in which the order has been complied. Stop. Next. Now I am afraid that the legality of the order passed in compliance of the order passed by this court cannot be looked into in the contempt application. Stop. Next. It will be open for the petitioner to challenge the same before the competent forum in accordance with law. Stop. Paragraph. Admittedly, it appears that there has been enough delay in complying the order passed by the court. What is your submission?
Well, I dispute submit my lord. Just now I am telling to my learned friend that whenever they complying with the order, they comes, my lord, they should have been given a warning that when the court, my lord, fixes a time, that should be maintained, and they should not take their time as they consider it fit and necessary. That is just now I am telling, my lord, it is, my lord, wrongly it has been done, and I'll continuing, my lord, to make that, my lord, the contentions to before the authorities, my lord, so that the time is stipulated, is complied with, and in the event there is some reasons, my lord, to delay, then they should come with an application for extension of the time. Your lordship, can I pardon this time, my lord? I am trying to, my lord.
Let an affidavit come forward.
My lord.
The alleged contemner is directed to file an affidavit with regard to the submission made on behalf of the petitioner, praying imposition of punishment on account of delayed compliance of the court's order by a fortnight. List on 21st December.
Gratefully. Your lordship.
Fortnight is already given, my lord, the first week of December, my lord. 8th of December.
Yes. আচ্ছা ঠিক আছে 8th of December টাইম যেখানে fortnight বলেছিলাম না, make it 8th of December. List on 21st.
Your lordship, affidavit of service.
Service taken on record.
Grateful.
Sorry, my yesterday I could not.
Why were you not there yesterday?
I missed the list, madam.
You missed the list. Very fast day. You got so many days holiday and you missed the list.
That's the reason. Holiday is the reason for missing the list.
I'm like, But if you kindly takes up my application, I had a talk with my client also, in regard to the purported resolution in which they have shown that my signature is there. And according to my client, has firmly said that no notice was served, no meeting was held, but the signature is his own. Yes.
How can that be?
And according to him, it was procured. But
Procured means?
that's why I want yesterday I talked to my land friend representing the municipality
Yes.
so that I can go through the original records and talk to my client once.
Abar.
Because I have again gone through the rules also. The meeting is the resolution is not in the form as recorded in terms of the statute. But if you kindly takes up their affidavit, I have in terms of Josh's direction they have served.
They means
The municipality.
which one?
Affidavit
Two.
of the municipality.
They have got two possibly.
I've been served with one.
You have one. Voluminous one.
Motata.
The voluminous one.
ক্লায়েন্ট যোগাযোগ করছে না গান্ধী আসছে না মনে থাকে নাকি
I've been served with in any event, the first one.
Yes.
Kindly take note that there are 3 kinds of meeting held in the municipality.
Which page?
I'm coming to that. The second page. First is the ordinary meeting for which 7 days notice is required in terms of Rule 8, and extraordinary meeting. This has 2 forms of meeting in extraordinary meeting. One is emergent meeting, and other is special meeting. For emergent meeting, 24 hours notice, and for special meeting, 3 days notice in terms of Rule 9. Now, kindly takes up page 2 of their affidavit, paragraph A, second last line. The prior permission, they held a meeting which is special meeting. Therefore, all subsequent meeting followed by should be a special meeting. This is not an emergent issue. Now, in terms of their affidavit, they have received the prior permission only on 27th December at page 22 of the affidavit. The letter was issued on 26th and it was received by the municipality, the seal on 27th. Now 28th was Saturday, 29th was Sunday, 30th the purported meeting was held. Now in any event,
and you appeared.
In any event,
that's all.
3 clear days notice was not there, and according to me, no notice was served. This is first. Second, kindly, on the basis of our complaint to the DLB issued an email to the municipality and sought for a reply from the municipality. At page 202 of the affidavit, the reply they have annexed.
এই তো বললি শেষ হয়ে গেছে বলে দিয়েছি বলে দিয়েছি দেখাচ্ছি আমি সত্যিটা একবার বলুন
And only after receiving this reply that the municipality has decided this. Now 202 of the affidavit.
Yes.
The email sent by the DLB is at page
202.
202 is the reply. 198 is the email of the DLB. 198. This is that is very important. 18 June 2020.
Yes.
Before the decision which is under challenge. Now, my lord, they have given a format. Format is starts at page 199. Resolution of the Board of Councillor, clause 2. Constituting selection committee for recruitment. Then all resolution of the meeting of the selection committee arranged date-wise in descending orders from the first meeting till the final meeting, recommending the names by name panel of candidates for approval of appointment of the Board of Councillors. Then all resolution of the Board of Councillors pertaining to the recruitment date-wise, including final meeting. Then 500-point roster. I'll come to that. That in their affidavit they have said they have not followed 100-point roster. They could not follow that. They have said that. Then copies of the advertisement. Then roster in format. Then whether written examination were held for recruitment. If so, the written examination was conducted by whom? How? Whether tender quotations were invited for selection. This is important. Therefore, this has some financial implications. That's why tender. Now, let kindly take some the rules. Then I'll come to them the resolution, purported resolution. Once again, kindly takes up. This is West Bengal Municipalities Procedure and Conduct of Business Rules, 1995. This book, do you have this book?
Yes.
I have handed over a copy. This is at page A448.
Yes.
Now let Rule 21, clause 2. Whenever at any meeting of the municipality, a motion or resolution authorizing any expenditure or authorizing any account leading to or involving expenditure is passed, the names of the councillors who vote for such motion or resolution shall be recorded in the minutes of the proceedings. Now, let's kindly look to the purported minutes. And in their affidavit, they have annexed. But this is the only meeting they have shown. May I come back? Page 23. This is the only minutes they have shown. No notice has been annexed to page 23 of their bulk affidavit.
Yes, 23. Yes.
Now, the previous meetings, they have given the extract of the meeting minutes that they have annexed, by which they have sought for prior permission. But in this case, they have given the original. I believe the photocopy of the original. Now, first two lines, this is in handwritten. হুগলি চুচুড়া পৌরসভা সদস্যগণের বোর্ডের বিশেষ সাধারণ সভার কার্যবিবরণী. Then স্থান, this is also handwritten. Time, this is also handwritten. Date also handwritten. And then আলোচ্য সূচি, this is in typed. I do not know the reason. They can explain. Now, সবার উপস্থিতি. First, serial 1, Sam Mukherjee. Then again, serial 1, Indrajit Dotto. And then at the bottom, the Honorable Chairman, Sri So-and-so, this is handwritten, took the chair and presided over the meeting. No resolution. And the next page, this is again typewritten. I have not gone through the original. I requested him, subject to your lordship's leave, I can look into it. Then let kindly see, this is the form of resolution, and nothing has been recorded who has voted for or against. Simply they have written the names of the members forming the selection committee. When the statute has prescribed certain forms, that has to be followed. Whereas my case is this has been procured.
Pages 23 and 24, the
Yes.
resolution also.
Yes. My specific case in the application, no notice was served, no meeting was held.
Is your signature appearing at page
Yes,
23?
At 23, I have talked to my client lad. He said, yes, this is my signature.
Which one?
Lad 3, Biplab Dash.
All right.
Serial number 2, 3, and 16.
2, 3, and 16, yes.
And 12 also. 12.
12 also.
12.
Yes. And my client requested me to go through the original ones.
All right. What to see in the original?
That according to them, that this is not the form how the
For that you are not required to go through the original.
This is one thing. No, whether how they have procured it, that whether any prior signature they have used it for this resolution or not. This has to be checked. In all occasions, they have taken the special meeting against at page 18. This is also a special meeting. They must follow certain forms while conducting or recording the resolution of special meeting. And every meeting has to be confirmed in subsequent meeting in terms of rule 8. I'm sorry, this is rule 14. Therefore, they have to place this resolution in the subsequent meeting in terms of rule 14 and has to confirm it to go further. Kindly takes up the rule once again.
Yes.
Now, rule 14, in absence of any question under rule 16, business shall be conducted at an ordinary meeting in the following order. The minutes of the last ordinary meeting and of an extraordinary meeting held thereafter shall be read, and if confirmed as correctly entered, shall be signed by the person presiding over the meeting as a token of such confirmation. In the event of any objection being raised about a resolution as recorded, the person presiding over the meeting shall be decided the question and may make necessary correction in the minutes book if required. But nothing has been at least brought before this court to demonstrate that this was placed in the ordinary meeting and confirmed. Unless the meeting is confirmed, it cannot take effect. And this is not an emergent situation.
Yes.
I request you to look into page 18. But they have given the extract of this meeting. This is also a special meeting. I'll request you to look into the original, how they have recorded the special meeting, how they follow, because the minutes book has to be followed.
No, the minute book was here yesterday.
They have I
they have it.
To give an inspection subject to losses leave. Because the allegations are serious.
Have a look at the original minute book. It is present before your lordship.
Page 80. Which
page 18. This is the extract of the meeting. This is the first meeting. They have said this is a meeting based on which they have sought for prior permission. They have played this in paragraphs.
Page 18. Please find out the original.
Kindly see, in the original, they have pasted this typewritten copy.
Pasted?
Yes.
In some other page, it has been pasted over there.
Yes. All these are pasted. This is not the resolution was recorded at the time of your meeting. Now, can you see? This what my client was in fact not apprehending.
What is the paste? Look here, sir. Sorry, paste. The usual time.
What, pasting?
Yes, yes. Kindly have a look to
Is
the
it recorded somewhere else and it comes?
Yes, it was typed elsewhere.
And may I have a look into it?
The usual practice. The usual practice.
Page 18, where do I get it?
Refer page 23. Resolution
20.
30th December 2019.
No, the page that you opened, this is the other page. Where is page 18? This one I saw.
First meeting.
These documents or these recordings are there in
Yes.
These resolution are to only special meeting.
No.
only special meetings. Page 18 is
Meeting that is altogether different.
No. They have stated in their affidavit that the 30th November is a special meeting.
30th November
It is
2019.
a special meeting.
I
Paragraph
do not
4A.
see. It is 9th March 2019 and then it comes to 30th of December 2019. Nothing in between.
Oh, just a second.
30th November 2019, no recording.
That was the general meeting.
No.
It was a general meeting.
No. Can you see their affidavit? Paragraph 2, page 2, paragraph 4A, last line.
That was
If that's a general meeting, then subsequent meeting in the same issue should be through general meeting. Why then a special meeting?
But then why is this type of practice adopted? You write it somewhere else, you cut it and paste it here. Why is it so?
May I have a look into this?
for other meetings are concerned, same practice is same.
Yes, but why is this practice adopted? Cut, paste.
Cut paste is not very popular.
Type text in computer.
Yes.
After signature, that is pasted resolution.
It is really cut and paste.
That is why I said it is cut and paste.
Not normal cut paste.
Not the regular computer cut paste.
30th November was the ordinary general meeting.
General meeting. Your learned friend says that you have mentioned it is a special meeting.
For amendment is confirmed that has been written as special meeting. That is
Mistake.
Oh.
General meeting.
How many mistakes?
This is a case where municipality is using two different affidavits.
Two different affidavits with mistakes.
With all mistakes.
December was the special meeting. 30th December was the special.
Where it is recorded that it is special meeting?
Page 2, paragraph 4A, last line.
Yes. Special meeting took place 30th November 2019. There is nothing.
And this is probably the last meeting book because the tenure was being concluded that at that relevant point of time. So the previous year's resolution book is required back.
So far notice is concerned, notice was duly served by sending messenger. They received the notice by putting their signature in the peon.
In the peon book, did you disclose anything?
That has not been disclosed in the affidavit.
That is not the
That is not the allegation. I have the photocopy.
No, because this is the issue that is being raised by your learned friend now. That these were not there, the meeting could not have taken place.
He appeared. He waived that right.
Where did he
In the
appear?
meeting, his signature is there.
He says that it is procured.
procured. Where he has made the complaint to the police that he has been procured by force, by misrepresentation. What is that statement?
This is the notice, and second one is the
Paragraph 6 of my application.
extract of your notice. May I hand over?
And this allegation has not been denied by the municipality. I have made a specific averment in paragraph 6, which has
Not
not been.
denied by way of filing affidavit. Otherwise, he says that you have.
This is from the bar. Nobody is taking responsibility.
No. But then, if documents show that you appeared in the meeting and you signed over there, then what does what remains?
That has. I have not even gone through the original matter. Now, if you has given me a chance, I can look into it because
Copy has been attached with the APT.
now,
Photocopy
2-3
has
things
been
that I have
attached.
raised. One is that whether all this issue is being decided in a special meeting, because the issue is relating to recruitment.
Yes.
And second, whether the resolution was made in terms of the statute. Third, if any resolution is taken, whether that was confirmed in a subsequent meeting. Because the subsequent meeting is held to correct the resolution of the first meeting. Therefore, whether it was confirmed or not. In the affidavit, they have said that this is a special meeting, the prior permission was taken. So, special meeting should be followed in the issue. Now they are saying, no, the affidavit is incorrect. It was taken in the original general meeting. Therefore, they have to show before this court, first, they have taken the resolution in any meeting on 30th November for seeking prior permission in the issue. And then, subsequent notice was issued for formal
Does
selection.
page 18 say so?
Page 18 is the extract of the meeting.
Yes.
And they says that this is a special meeting. The special meeting book does not disclose any such
No,
meeting.
even if it's a general meeting, does it say that it relates to recruitment or anything?
No, this is relates to prior permission. Yes. This is related to prior permission, based on which they issued the letter seeking prior permission. In fact, DLB in their query has sought for this letter. There was confusion of the DLB part also. Whether any prior permission was sought for. They are seeking prior permission to the DLB, while DLB is asking records from them whether you have sought for any prior permission or not. Because there was something which is not on record. That's why all this information was sought for by the DLB. And whether this was subsequently confirmed or not, that has to be looked into. They have not disclosed in the affidavit.
What is to be confirmed?
All the minutes or in the subsequent meeting in terms of Rule 14.
Ratification type of thing.
Ratification.
Hmm.
So, this has to be disclosed. This has not been disclosed. When I have said the annexure Swansu is manufactured, they have to justify, no, it is not.
Did you file any affidavit to the application? Nothing.
No. There was a direction.
There was a direction.
Yes.
And you did not. You chose not to file. What happens? The principle of non-traverse will follow. Then what's going to happen? Why are you not denying or admitting or whatever your stand is? Why don't you file it by way of an affidavit? Because the matter is not going to end here. The matter is sure to travel up. So without the documents, will it be proper to decide it?
Because the matters were moved quickly. The number of 16 applications with regard to self-examination were filed both this month without the COVID interview. So for this particular matter is concerned, initial first affidavit, thereafter the chairman changed our land also.
Changed with the change of the chairman. I would like to know your stand with regard to the application that has been filed by the private respondents objecting to the entire process of recruitment.
And one more thing, can you look into page 28? In their resolution, they have never disclosed, never deliberated who will be the agency, particularly when this issue was raised by the DLB lawyer, that in one day they have completed everything.
Yes.
Now, kindly page 28,
28.
It is the, in terms of the rules, it is the selection committee who has to decide.
Hmm.
Now I'm at page 28, clause 7, Roman clause 7.
Hmm.
It is unanimously resolved that the preparation of question paper is imposed upon the chairman. The answer sheet will be evaluated by the question setter. The chairman has proposed that he will get the examination process done through an agency, maintaining the secrecy. Hence, no coding and decoding process is to be made. But it is the selection committee who has to decide all this. And the statute does not empower by the selection committee to delegate its power to somebody else. Therefore, again,
But at the same time, the selection committee did not delegate this power.
the selection committee was supposed to conduct the selection process.
Right, but the selection committee did not delegate it. The chairman took it up for himself.
Yes. No, this is the selection committee. They have shown this is the meeting of the selection committee.
Oh, the selection committee delegates
yes.
it to the chairman. Proposed that he will get the examination process done.
Yes.
Chairman has
So,
proposed.
in fact, chairman proposed and chairman is done doing this. And then that chairman filed that previous affidavit and the chairman changed, the affidavit is changed. So the trust on the municipality, this is statutory authority. The trust which we have reposed on the municipality is being getting frustrated. That's the whole difficulty as a public issue. This needs to be gone into
Lots of
I
question
believe
mark
in
is
deed
coming
decision it
up.
is difficult.
May I answer? Many things has been said.
You will answer 1 minute. Let him finish. He has got
But
a
he
lot
has
of
finished.
queries. A lot of question marks put to the recruitment process.
My lord is hearing a writ petition initiated by the candidates who were selected and recruited. One fine morning, minister thought that recruitment process is not bad based on a document. Can you mark my submission? Based on a document, he reopened the entire process and cancelled it. That's the subject matter of challenge. Well, just my learned friend hearing me, hear him, one judgment was coming in my mind in a civil procedure, my lord. If a lease is pending, a suit for eviction cannot be converted to a suit for title. There is some grievances of my learned friend against the then committee. They were deprived from not participating. Those are the dispute they never raised. I repeat, they never raised. And your lordship will find from the documents before your lordship that a letter which prompted the minister to recall this, whether this letter can give a cause of action for the minister, even if he has power. I am disputing he has no power. Can do it. Well, can you once look to that? The candidates who never participated in the selection process complained. Candidates who never participated in the selection process complained that there may be some irregularities. And that prompted the minister to recall everything. And the report says everything is possible. Admit card may not be possible to reach. All surmise and conjecture. And then now, my lord, Advocate, what you are saying before my lord is submitting before my lord is not find place in his application. He is saying the application only says that his signature has been procured. No, not even that. He said these documents are never executed. Never signed. This is the case made out in the petition. But before that, kindly once allow me to place the letter which prompted the minister to recall the entire.
You have placed it on the earlier.
No, that I have not placed because it was not known to me that this type of submission will be made by persons who have some animosity with the then councillors, who has nothing to do with us. And he has never raised any complaint before that. But kindly look to that page.
Merely sign. The page 10 of the opposition.
Kindly come to page 10 of the opposition.
Of state.
Of the state. The report of state. Well, kindly come to this. Page 10, have you logically got it? The thinner affidavit in opposition.
A lot of documents.
The nomenclature is affidavit on behalf of the respondent number 1 and 2 in terms of the solemn order dated 3rd February 2023. Back seat is, my lord, Mr. Adok. Shubhendu Adok. Shuddhadev Adok.
Which page?
Page 10.
Yes.
Allow me to place it. Address to the minister in charge. মহাশয় আমি তাহলে মার্কিট আমি বিনীতভাবে আপনাকে জানাই যে আমি হুগলি জেলার একজন বেকার যুবক। আমি কিছুদিন আগে দেখলাম যে হুগলি চুনিসুরা মিউনিসিপ্যালিটির মজদুর পিয়ন সহ অন্য পদে লোক নিয়োগ করেছে ডান এবং ইতিমধ্যে অনেকে চাকরিতে যোগদান করেছে, কিন্তু অনুতাপের সঙ্গে জানাচ্ছি যে উক্ত পদগুলিতে নিয়োগের ক্ষেত্রে চূড়ান্ত স্বজনপোষণ হয়েছে এবং অযোগ্য ব্যক্তিদের নিয়োগ করা হয়েছে, অথচ আমার মতো অনেক বেকার যুবক যুবতী চাকরি সুযোগ থেকে বঞ্চিত হয়েছে। তাই আপনার নিকট আমার বিনীত প্রার্থনা এই যে আপনি নিয়োগ প্রক্রিয়াটি তদন্ত করে দেখুন এবং তদন্তে দুর্নীতি দেখা গেলে নিয়োগ প্রক্রিয়াটি অবৈধ বলে ঘোষণা করে পুনরায় নিয়োগের জন্য পরীক্ষার ব্যবস্থা করলে আমার মতো অনেক বেকার ছেলেমেয়ে চাকরি পেতে পারে। My lord is dealing with these types of cases nowadays, where my lord will find in each and every case the deprived candidate has approached your lordship's court, saying that by this illegal procedure I have been deprived. I was the eligible candidate, participated in the selection process, deprived me wrongly. This is the letter, my lord. Can it be, had it been placed before my lord in a writ petition, can my lord has given any cognizance? Supreme Court times without number says that if you are not participating in the selection process, you cannot the selection process, and this is not a public interest litigation. And it starts with AMI and then signature procured. And this is the reason the minister in charge reopened the entire issue. Because when this is up-quoted, because when the earlier selection was done, he was not the minister in charge. That's the reason. Now, my lord, kindly see the order. Okay, now I can take it. But this is the report. If you lordship kindly see, along with that, the report was annexed. But kindly come to page 12 of your lordship brief. 2. Subject matter of inquiry. Has my lordship got it? I not place the entirety. Kindly come to column 2, last lines, right hand side. The said recruitment already conducted by the municipality vis-a-vis the procedural lapses, if any, which may have occurred during the said period. Totally surmise. Kindly proceed. Kindly come to the bottom. Kindly turn over. Kindly come to 5. Paragraph 3, 5. Paragraph. Apart from the provisions as stated here above, no standard procedure has been observed under the West Bengal Municipal Act 1993 or rules framed thereunder regarding the modalities to be followed by the selection committee for the direct recruitment in group duplexes. Absolute wrong before the lordship. My lord has seen that. Procedure laid down, selection committee formed, selection process conducted, everything has been done in accordance with the law. So this finding, the report, based on which my lord is hearing the matter, is absolutely baseless. Then my lord kindly see 6. The director of local bodies such as the department accorded necessary permission in favor of the municipality for filling up 9 posts of peon and 67 posts of mozdoor. So permission was also accorded. Then my lord 7. The municipality on receipt of the permission from the DLB constitute a selection committee. This is the report. Then kindly come to 8. The first meeting of the selection committee was held on such and such date. All the other members, including the deputy director of local bodies, Ward 1 division officer, was present. It appears from the copy proceedings of the said meeting that the following decision has taken. Determination of the reservation. Then B. Advertisement inviting application to be published in 2 widely published leading lady newspaper along with the municipal website if available and in the office notice board. This has been complied with. All are on website apart from the notification in the public newspaper. Then local employment exchange also informed. What remains, my lord, I am asking myself this question. Then kindly turn over. 9. First meeting. The method of selection will be on the basis of written test of 50 marks and viva voce 10 conducted. G. It was decided that the first 5 highest scorers in each post will be called for interview. So So this was on the basis of the total number, it has been done. Then H. The last two lines kindly see. The applications received are inclusive of the names sponsored by the Employment Exchange Office. So all were taken into consideration. Kindly turn over. The second meeting. The second meeting of the selection committee was held on such and such date. Srimati Mausumi Vasu Chatterjee, all the other members, including the deputy director of local parties, whatever was present. My lord, kindly pause here for a moment. My lord has seen that lady has subsequently authenticated that he was not present, but subsequently has accepted the entire selection process which has been conducted. Then, kindly come to D, the bottom D. The responsibility to send call letters by post to the qualified candidates for interview was entrusted upon the president of the selection committee, that is the chairman of the municipality. The gap between the date of posting the call letters and date of high verbosity test shall be at least 15 days. But what is the violation? I'm asking those things to myself. Then, my lord, kindly come to 11. I'm only placing the 11 portion, which according to me is 11. Kindly come to 11, clause D. There is no allegation the people notice was not there. Any candidate has said, I have not received. None has come. Then, there is no such rule. That's why I said nobody complained that I have not received any admit card letter. That's admit card. That's why I could not participate in the selection process. Then D, it was decided in the meeting to place the panel and recommendation of the selection committee before the special meeting of the board of councillor for consideration and approval. Then, my lord, 12. Kindly come to A. However, as discussed in the second meeting of the selection committee, no supporting resolution of BOC was found regarding decision taken in the BOC meeting for presentation of question papers and concluding the examination process through agency. Now, this is not the, my lord, allegation at all. That has been done. The record is before my lord. Then, my lord, then kindly come to 13, interview process. This is probably the allegation. The municipality fixed a single date for holding interview to the post of Moju such and such and such. Thus, the municipality called a total number of 414 candidates for the interview on a single day from 11 a.m. onwards. The municipality informed the members of the selection committee according to the date number such and such. Out of the total 414 candidates called for interview, 43 candidates attended. Even, my lord, this out of 414 called for, 43 appeared. Rest was not complained. They got the admit card, admittedly, because when the 414 candidates was called for the interview, they got the admit card. They never came back and said, no, I cannot appear in the, I could not appear in the interview process because I don't get the interview admit card letter. None came till today. 43 candidates attended the post of peon and 370 candidates sought for the Mozdur. Thus, a total number of 350 candidates appeared for interview on such and such day, which was scheduled on such and such date. Then, in response to this query, the municipality submitted the proceedings of the third meeting of such and such. Then kindly come to 16. By memo about such and such, the municipality requested the director of local bodies West Bengal to accord approval to the appointment to the post of Mozdur and peon respectively. Approval accorded. Then the approval accorded. Well, now, some mistake in the process. What are the kindly come to page 21. The first meeting of the selection committee, which was held on 6th January 2020, decided to send the admit card call letter to eligible candidate by post only. Nowadays, a matter of convention. In addition to sending the admit card, this is not the law. Candidate admit the postcard seeks to have taken various selections to inform the candidates the date and the time of the examination by way of publication in newspaper, sending bulk SMS to the mobile number of the candidates and following the candidates to download their admit card from the website to avoid complications that might arise for postal delay or non-receipt of the admit card through postal receipts. However, in this regard, no attributable measure, alternate measure appeared to have been decided upon by the selection committee other than the only method of sending the admit card post. Perhaps, well, kindly mark the word. I request you to mark the word. Perhaps having some scope for non-receipt of admit card by candidate through the only mode of delivery of post. This is the allegation. This is one of the allegations that you have not sent it other than post, so it may lead to some. I say, kindly mark my statement here that no candidate who participated in selection, sought to participate, has complained that they have not received admit card. Then, in the second meeting of the selection committee, which was held on such and such, it appeared.
Prior to moving any further, I would like to know whether the corporation would like to file or the municipality would like to file an opposition to the private respondent's application or not.
I
am
cannot
saying
stand in the
this.
way. I
Yes.
cannot stand in the way, but I request your lordship to look to the allegation in the application. It is necessary. If my lord think necessary, yes.
No, it is for the municipality to decide whether it is necessary,
If there
because
is no allegation.
Because let the municipality say they will not decide, I will record and then move forward, because the matter is sure to go up.
I don't think so. No candidate has complained of. That is the main thing.
The applicant over here will go up.
Applicant, let him go. I am not concerned. My lord, if my lord has seen, I repeat. Can you pardon me for repeating?
It will delay the matter further.
This is being delayed. I am out of employment.
This is the reason I want to finish it up
Another
fast.
thing, my lord, can be done. I am a permanent employee without any proceeding. Can I be, my lord? Can I be, my lord, out of employment? This is one of my point. I am a permanent employee, no doubt about that. I accrued the status of my employment, and that has been thrown away.
What will be your stand?
My lord, before that, my lord, once hurriedly gone through the allegation.
You have read this. I have marked. I've seen everything.
Accepting that the signature is subsequently says is not only one paragraph, paragraph 5, not signed. This is the only allegation.
Yes, it is not signed. That is the only allegation.
Kindly once I request your lordship have taken
Whatever has
lordship's
been
time.
argued, that has not been
Kindly
pleaded.
once hurriedly gone through his application, accepting that, is there any allegation? I know I am taking my lord's time. Kindly pardon me for that.
No, not court. Apart from the court's time, the writ petitioners will
I appreciate my lord's anxiety for that also.
Yes.
But if your lordship thinks anything is there,
Is
whatever
it
argued, my lord, from bar.
What is CAN 7? Is it CAN
Yes,
7?
This is CAN.
No. CAN
Number I don't know. Backseat of Mr. Sami Ahmed.
CAN 4 possibly? No. Application for urgent linking.
Can 3
Intervention.
3
CAN 3.
Well, headline is, my lord, an application for intervention. Hurriedly, kindly go through this. Is there any allegation vis-a-vis the recruitment of the writ petitioner?
The points asked today, the points asked today.
Now the point sought to be raised is the invention of Mr. Ahmed.
Not there in the application.
These are the points.
His persuasive eloquence, my lord, has done. Your lordship can take up my copy also.
Read out what is there.
I don't want to waste your lordship's time, because accepting paragraph 5, my lord, accepting paragraph 5, well, I don't think there is any allegation. He says only he has not signed that. And now that the ratification in the subsequent meeting, these are all, my lord, from the bar.
Paragraph 6, paragraph 7.
Yes, CAN 3, I've got it.
5, 6, 7.
Intervention.
Can you read? What he is saying, can you read that?
খালি বলতে রেজলিউশনটা জাল এটাই বলে গেছে 5 6 7 কিছু বলে rule challenge করেন।
And this is purely political dispute. Ruling party, that.
No
this is
such
allegation.
notice or document P12 was ever executed.
Yes.
12 is manufactured. No such decision relating to
That my lord has seen
employment
now.
was circulated. Purported resolution is also manufactured. Undated resolution P12 must have been manufactured.
Then paragraph 6, the favoritism part.
Oh, that you cannot say. You are not the candidate there.
One of the councillor, 2 of the council has been appointed.
You are not the candidate there. You have not participated in the selection process. You cannot challenge the selection committee or the decision.
I'm the authority who has to
Settled
take
law.
the decision.
This is a law settled by the Supreme Court.
It's nothing. Argued today is part of
Paragraph 7 is detailed one. A, B, C, D.
Even, my lord, that is not there.
That is not there.
favoritism, only favoritism.
In the petition, is there any substance, my lord? Kindly-
Paragraph 9.
Yes, yes. We have read it. You now cannot say this. My lord has seen the resolution, they have participated.
Letter of the minister has not come, or rather, what they have taken at the dictate of the minister is not come. One fine morning, there was a complaint from different corner. They have sought for information by email. On the basis of
The
all
state
those
affidavit will
information,
speak for it. State says,
and
this is the only letter.
And municipality also in their affidavit said that no fund was disbursed by the DLB because of these irregularities.
This is a recruitment process.
So whatever they may be employed, but this was not approved by the DLB. Fund
approved. Very
fund
good.
was not released.
What will be your stand?
My lord has seen, just a minute, madam. My lord has seen, is there any allegation which is now sought to be read from the bar?
No, these are points of law. So,
without a fact. And you want to convert
What
this
will
suit?
be your stand?
Municipality cannot say anything. Everybody has changed his stand. It's very difficult.
And this is a big question mark. How could the municipality change stand?
My lord,
With the change of
this
chairmanship,
is a case with due respect.
stand.
My lord,
No,
with
with-
opening remarks, I indicated what is the reason behind it.
Yes, I have followed it. But sitting in a
Same
court
thing
of
happens
law,
when the regime is
constitutional
changed.
court.
My lord is saying when the regime is changed, the same thing happened. Whatever they have done, this is all illegal.
To sort out the issue, may I submit this? Here, whatever the stand of the petitioner, they are justifying their stand
Obviously.
because they are an employee
Yes.
whose selection process is under challenge.
Right.
In other way, now all these issue,
Not a challenge. I am sorry to say.
all
interrupt.
this issue, is difficult to be determined by the writ petition because of some factual issues has to be gone into. This can be done by a inquiry. If you just kindly form an inquiry, I'll give the points. Let them also let the issue, the facts be come forward, the clear picture, because the municipality has taken two different stands. The state government has conducted an inquiry, filed the report.
Let the municipality first say what you want to do with this CAN 3. Do you intend to file an opposition or not?
Kindly fix it on the next week. Meanwhile, we can take instruction.
No, not instruction. I can fix a date. But then if you want to file an affidavit, you have to file it on that date. Otherwise, no further date. The petitioners are out of employment for quite some time. No proceeding initiated against them. Why should they suffer?
Kindly give 7 more days. Meanwhile, I shall come back either with the instruction or with the evidence.
I won't require any instruction.
Instruction affidavit.
Yes, if you intend to file an affidavit, file. If not, no. Because as I told, this is sure to go up.
But kindly consider my submission. Whether a suit of declaration can be converted to a suit for.
This is rich court. The principle of suit is not applicable here.
Please come.
Principle of CPC.
Obviously. You are converting is not a public litigation also.
Heard detailed submissions made on behalf of the petitioners, the municipality, and the interveners. Stop. It appears that the municipality has not filed any affidavit. Apropos, the application being CAN 3 of 2020 filed for intervention and necessary direction. Stop. Learned advocate representing the municipality seeks time to take instruction in the matter as to whether to file an affidavit to the said application. Stop. Next. As it appears that the writ petition is pending for quite some time and the petitioners are out of employment, the court is not inclined to delay the matter any further. Stop. As last chance, the matter is adjourned till when? One particular day, we'll finish it up.
Monday week.
Monday week is a holiday. 27th is a holiday. 29th, 29th, November 2023. Stop. In the event the municipality intends to file an affidavit, comma, the same shall positively be prepared and served upon the learned advocates appearing on behalf of the respective parties by 24th of November 2023. Stop. List on 29th.
I have, in fact,
Character line, in the event no opposition is filed or filed on the adjourned date, comma, it will be taken that the municipality does not intend to file an opposition to the application filed by the interveners, and the writ petition will be decided on the basis of the documents already available on record.
and when if they use this affidavit, I shall be at liberty to file reply to that within this period. Within this period.
Request, madam. My lord has seen the change of stand by the municipality.
Yes.
So, my lord, kindly record, subject to my lord's pleasure, that my lord has produced the original resolution book and find that he has appeared in
all
the
resolution book has not been placed yet.
Whatever you have, my lord, has seen.
For the court, and I have seen it.
This is in
Record
respect of the only one meeting.
One
They are
meeting.
only one meeting. There are other meetings. There are meetings rather, which is will be appearing from the reply given to the DLB.
Where are all these things in your application?
Nowhere.
My case is no meeting. They
Yes,
are saying they are a boys meeting. Let them. They have to justify they are meeting. They have to produce the records.
Very well. If that is your stand, they will file opposition. They will disclose whatever is there. In the event there is anything.
Kindly record the only meeting book dated so and so.
Special meeting.
There are meeting books.
Be it recorded that the special meeting book of the municipality
For the year
was, yes, give me, for the year such and such,
Meeting dated 30th December.
has been produced in original before this court. Stop. The court has produced the resolution recorded in the said
in fact,
minutes book. Resolution dated 30th of December 2019.
Where all the applicants have signed.
Where, my lord,
rather kindly record the type copy pasted on the resolution.
Oh, it is there. Not recording. You cannot record each and every word.
My lord, can I record that my lord has find the signature of my landed defense client?
He admits it. He admits it.
So the party jhagda party te kar na baba.
Same position তো বলে দাও বলে দাও বলে দাও same position.
I hope it will be
Yes,
same.
yes, urgent motion.
When the conservancy issue has been reported, my lord, they have said they will take prompt action, my lord. A new contractor has been appointed in November. That is why some hiccups. We shall take care.
Do you travel by that road? Do you travel? Have you seen?
In many places.
Many
But
places.
these are new. They said they are new issue in November because a new agency has been appointed.
If
November.
that matter appeared, it will again done.
Mr. Banerjee is here.
Cannot do
No,
without.
no, it is his personal problem also.
Maybe when the matter was taken up, that matter, he was there.
Yes,
But he could not do anything unless the court directs.
But I beg to appear for the petitioner, my lord.
Yes.
I have sub, my lord, the memory municipality, my lord, by hand service, my lord, 10 days.
Municipality.
Memory municipality, my lord.
Emery.
My
What has happened?
But here, my lord, my sanction plan was not granted, my lord. I have applied for sanction plan on 2nd June 2023. If I take your lordship to the relevant documents here, my lord, very quickly, my lord.
Has it been rejected?
Neither accepted nor rejected, my lord. They have made scrutiny, my lord, and from the document also I will show, my lord, everything has been satisfied. If your lordship, my lord, kindly first take, my lord, I shall satisfy your lordship with all my documents first, my lord. Thereafter, I will take you to
Show me
your.
your application for sanction.
Yes, my lord. Then
The
for
plan
my lord,
proposal.
kindly comes to, my lord, by application, my lord. That application, my lord, is, my lord, at page 50, 58, 50 to 58, my lord. This is the most important, my lord. Now, my lord, your lordship knows, my lord, we have to apply, my lord, through online portal, my lord. And my lord, before that, my lord, you also see, my lord, after application, my lord, they have made, my lord, the inspection. This 50, my lord, your lordship will find, my lord, that they have come and uploaded the inspection, my lord. Your lordship will find the photograph at page 53. Page 53, your lordship will find, my lord, the photograph, my lord, they had been uploaded by the concerned municipality only, my lord. And my lord, before that, my lord, kindly comes, my lord, also to, my lord, page 45. My scrutiny report of building plan. Here, my lord, your lordship will find, my lord, from scrutiny report building plan, my lord. Your lordship will find, my lord.
Scrutiny completed.
46, my lord, kindly see all the parameters has been satisfied. 46, my lord, see, my lord, 46.
Please come.
And my lord, scrutiny completed, my lord. Scrutiny had also been completed.
The plan proposal.
And my lord,
submitted by the petitioner online for sanction of building plan is yet to be disposed of. Stop. It appears that the site photographs for the building plan was duly uploaded in the online building plan approval system portal maintained by the Department of Urban Development and Municipal Affairs. Stop. The scrutiny report of the building plan mentions that the scrutiny status is completed.
but I have made 2 applications, my lord. Thereafter, my lord. Kindly see, my lord, at page PP8, my lord, on online, my lord. Online portal, I have made a complaint, my lord, on 3rd August 2023, my lord. And also, my lord, a representation, my lord, at P9. P9, my lord, 3 to all the concerns, my lord. Here, my lord, I have taken specific point, my lord.
When was the application submitted?
Submitted, my lord, on 3rd of June 2023. My lord, 60 days passed, my lord. Your lordship knows,
Where do I get that date?
That date, my lord. I am giving to you, lord. But kindly comes to, my lord, page. That date. 1 minute, my lord.
And so the application was filed
40,
online.
Kindly come to page 14.
When?
But 1 minute, my lord. Kindly see, my lord, 5th June, my lord.
On 2nd June 2023.
2nd June 2023, my lord.
But till date, the same is yet to
Yes, my lord. Page 42, my lord. Page 42, my lord.
Disposed of.
Date of receipt of application, my lord. Kindly see. After 4-5 lines, my lord. 2nd June 2023.
Municipality ought to have taken a decision with regard to the plan proposal submitted by the petitioner seeking sanction.
Within 60 days.
Within a period of 60 days. Stop. The said time period has elapsed long back. Stop. Next. In view of the above, the instant writ petition is disposed of by directing Memory Municipality to pass a final order apropos the plan proposal submitted by the petitioner seeking sanction for raising construction positively within a fortnight from the date of communication of this order. Stop. Next. In the event there is any deficiency in the plan proposal, the same shall immediately be communicated to the petitioner for removal of the defects. Stop. Next. None represents the municipality. Stop. Affidavit of service taken on record. Writ petition disposed.
Deeply obliged.
Is this your matter?
Number 6.
Yes.
Well,
Who is your other side?
Service has been completed on
Yes.
Vidhannagar Municipal Corporation.
What is the matter?
Well, the matter is an allegation had been made that my client has made unauthorized construction pertaining to a window sill and a covered veranda. Now, my lord, it so appears that the matter will not end within regulation time. It will run into extra time. Now, my first limb of argument is that no court at any stage, at any point of time, has gone into the merits of the case. Lordship will kindly take up page 34 of running page 34
Yes.
of my petition.
Yes.
Or rather page 35, the very next page. In the middle, Lordship will find, is your Lordship's observation, it is made clear that this court has not entered into the merits of the claim made by the petitioner, and all points are left open to be decided by the aforesaid respondent at the time of consideration of the representation of the petitioner. Now, Lordship will kindly come to Annexure P7, particularly at page 41-42. This is
Has
when
the private respondent been served?
sent by speed post, my lord.
Certainly, it could not have been served by a day. So, somebody appeared for the private respondent in the earlier writ petition. From page 33, I can see the name of the learned counsel.
Mr. Banerjee appeared. Mr. Banerjee appeared on behalf of the private respondent. Mr. Shuddhashatha Banerjee.
You can serve a notice upon the learned advocate,
my lord,
so that the matter is not taken up ex parte and
my lord, no question of taking up ex parte. What I'm trying to impress upon my lord is that at no stage has the merits of the case been visited by the court. And hence, one needs to go deeper into the matter and see what is the dispute really all about.
but the reasoned order appears to be a detailed
my lord,
one.
before I place the reasoned order, may I place page 42?
Should it be taken up in the absence of the private
My
respondent?
lord, this is all. I'm just trying to impress that the merits have never been visited by this court.
Very well.
Now,
So,
this is not an allegation.
are you apprehending that immediate steps will be taken by the corporation?
Yes.
Yes, is the corporation taking steps immediately?
But today, the corporation has reopened after the puja vacation.
Right.
So I really do not think that there are any scope of me, my lord, taking immediate action of demolition. But if my learned friend is can satisfy your lordship, then he can, my lord, press the application. Otherwise, my lord will kindly take up on Monday or any day. Or in the presence of, as of now, there is no
Take up
instruction.
the matter when the private respondent is here and all the parties are represented. The corporation says they will not take any steps.
Well, let it be recorded that they will not take any
I
steps.
cannot, my lord, give any undertaking.
No, no.
In that event, Lordship will kindly prevent them from doing any harm to me.
I'll keep it on the 22nd of November. You give one notice to the learned advocate who represented the private respondent in the earlier writ petition. Please come.
22nd.
The reasoned order dated 30th of October 2023, passed by the Vidhannagar Municipal Corporation, is impugned in the instant writ petition. Stop. Next. The private respondent is not represented. Stop. Next. Let a notice along with a copy of the writ petition be served upon the learned advocate who represented the private respondent before this court in the earlier writ petition filed by the private respondent. Stop. The matter stands adjourned till 22nd of November 2023. Same heading it will appear.
My lord, till then, let the corporation not, my lord, take steps to.
In the event they take any steps, the court is here. Come, the court will immediately take up the matter. 7. State. Where is the petitioner?
I'm for respondent number 5. I'm for respondent number 5.
Petitioner is not there.
Last time also not.
They get into. None appears on behalf of the petitioners at the time of call on repeated occasions.
7.
Sir, my lord, 7 and 8, the kindly fixed at 24th because analogous matter on fixed on 24th. This is cooperative matter.
24th.
But not 24th, Lord, so I will not be here. I may not be here, Lord, so I think. 23rd and 24th. The very.
Next.
I have not.
Thereafter. আচ্ছা তাহলে একটা লিখুন on the prayer of the learned advocate representing the petitioners, list on when 8th of February. Same order in item number 8.
Identical issues involved. It's a personal matter.
Identical issues.
Personal
Record the appearance of the
issue is
state.
involved.
7 and 8. You are there in item 8 also, Mr. Mitra?
Yes, my lord.
Very good. 7 and 8, both.
For respondent number 5. In both the
Amitabh Mitra.
Yes,
দুটোতেই response, state respondents.
7 8
Yes, 9.
Your Lordship, Mrs. Dhabal is appearing for the petitioner in this matter, Your Lordship. Item number 9. Your Lordship, her mother-in-law is not well, Your Lordship. I'm praying only for not today, Your Lordship.
Very well, not.
Grateful, Your Lordship.
Adjourn for the day. Adjourn for the day on the prayer made on behalf of the learned advocate representing the petitioner.
Grateful, Your Lordship.
Eleven.
Item 11, and for the petitioner, Your Lordship, Mr. Shubhra Prakash Lairi is approving. See, Your Lordship.
Lord, I'm for the petition in this matter, my lord. This is,
Chandanagar Municipal Corporation.
my lord, possibly the service is required to be made upon the Chandanagar Municipal Corporation. My clerk has lost the track report, my lord. I'm making a fresh service upon them. I've served the private respondent. It is delivered. But my lord,
Please come.
the track report is not available with us, so I could not put it in the.
There is no proof of service of the writ petition upon the Chandanagar Municipal Corporation. Stop. Next. Let the writ petition be served upon the corporation. Stop. None represents the private respondents. Stop. Let notice be served upon the private respondents. Stop. List on 11th of December.
I'm grateful to your lordship. My lord, will it be possible with prior if it suits your lordship?
Today is a very suitable day.
I understand, my lord. that I've lost it. That is a difficulty.
Next.
Okay, so, grateful.
12. Petitioner.
I am for the petition.
What is the matter?
My lord, illegal and unauthorized construction, my lord.
Howrah Municipal Corporation.
My lord, in the meantime,
Stop.
the matter of upgradation was served. It has come to our notice that the private respondent, one of the private respondent has died. So we need to make out an application for substitution. Private respondent number 4 died.
Did you file an application for substitution?
No. We are about to
You
file.
intend to.
We intend to.
Please come. It has been submitted by the learned advocate representing the petitioner that during the pendency of the writ petition, Respondent number 4 has expired. Stop. The petitioner intends to take out an application for substitution. Stop. Next. In view of such submission, the matter is directed to go out of list. Stop. Necessary steps for substituting the deceased respondent be taken in the meantime. Stop. Affidavit of service. Affidavits be written with the records. None represents Howrah Municipal Corporation.
Well, I'm for the petition.
My lord, I am appearing for the state, my lord.
Yes.
Well, unauthorized construction has been made, my lord, by.
Who is the authority?
Maheshwara
Maheshwara Municipality. Who is there? Let me see. Maheshwara Municipality.
Paragraph 8.
Paragraph
Says
8.
lordship will find.
Did you serve the municipality?
Yes. Municipality has a-
Please come.
My lord, this is the instruction from the state.
The petitioner alleges illegal and unauthorized construction at the behest of the private respondents. Over piece and parcel of land situated at page number 19. Schedule property রয়েছে একটা মৌজা থেকে কপি করবেন bracket portion. Stop. Objection lodged against such unauthorized construction is pending consideration. None represents either the Maheshtala municipality or the private respondents. Stop. Affidavit of service taken on record. Stop. In view of the order that I propose to pass, comma, none of the non-appearing respondents would be prejudiced if the writ petition is disposed of in the following manner. You did not make the municipality a party. Not the municipality, nor the board of councillors.
Your lordship kindly grant me liberty to, my lord, at the.
Mahesthala municipality will take a decision. Representation is 2nd June 2023. Writ petition disposed of.
Or within a stipulated time.
12 weeks.
My lord, instruction of the police authority be kept on record.
Instruction forwarded by which police station?
Maheshwara police.
Mahesthala police station.
Rabindranagar police station. Sorry, my lord.
Rabindranagar police station. Date kato? Date dated such and such be written with the records.
So by that time, my lord, they will complete, my lord, the entire construction, my lord.
If they complete, we will demolish it.
There, my lord, your lordship knows, my lord, if these type of developments, then third party right will, my lord, the acquired, and then, my lord, it will be.
Please call the next matter.
But some lesser time, if your lordship kindly grants.
14, my lord, I beg to appear.
14,
my lord, I beg to appear for the petitioner, my lord. In this matter, my lord, allegations of unauthorized construction, my lord, commercial activity going on. But I have not served, my lord, notice of upgradation both upon the private respondents as well as the official respondents.
My lord, I am not appearing in this matter, but I believe item number 18 of your lordship's list today is possibly, my lord, by the same petitioner with
similar-
regard to the similar premises.
Similar premises, my lord.
why
14
two
and
writ petitions? Same
my lord, one,
parties?
my lord, alleging, my lord, unauthorized construction, one, my lord, representation, my lord, the other deals with the unauthorized construction and, my lord, the commercial activity going on in the residential premises, and, my lord, no fire license is there in that premises.
Unauthorized construction allegation is there in both the writ petitions.
Yes, my lord. Therefore, my lord, a common order may be passed, my lord.
Show me 18 also. And is there any private respondent?
Yes, my lord, I have served.
In both the matters, same private
The
respondent?
same private respondents, my lord, I have served. And my lord, notice of upgradation as well has been served.
Very well. What is the stand of the corporation?
But I'll just tell your lordship, but I am, since I'm in 18, but I was just comparing the prayers of 18 with 14. But I find prayer A is not identical. Even the representation date is same.
Yes, what is your stand?
Yes, I tell your lordship, my lord, I have been able to procure it from my learned friend right now. But I find that, my lord, I'm handing it to your lordship.
Pass it on.
Lordship. Lordship will possibly have the second last point is lordship will possibly fall, query will fall from your lordship.
18 নম্বর ব্রিফটা লাগবে।
কোথায় পেয়েছি আমি পাঠিয়েছি হোয়াটসঅ্যাপে। আচ্ছা আমার একটা কথা বলো, এইটা এই যেটা দিলে এক্ষুনি, এই যেটা বলছে না লেটার অন হায়ার অথরিটি ডিসাইডেড টু পুট দ্য ম্যাটার ফর রিহিয়ারিং, এটা কেন? ওই রিপ্রেজেন্টেশনের ডেটটা কত?
Please come. In your representation, did you mention what is the illegal construction that has been made?
The entire building has been constructed without any sanction plan, my lord.
Entire building?
Yes, ma'am.
And what is the height of the building?
This is not a G+2. The building is not G+2 story building, my lord.
দুটো writ petition. Item 14 and item 18. Both the writ petitions are taken up.
My lord, only one objection, my lord. What if it lordship will pass, will shall obviously take steps. But my lord, will your lordship entertain two writ petitions with exactly the same petition, same prayers? One has to go. Same representation, same date, same prayer.
Same prayer also.
But as far as I can, prayer B is identical. To consider representation, as far as my lord, if I may just 14 number to kholo. To consider the representation at 20th June and initiate proceedings on the 401A and 401A. Then that is prayer B in 18 and prayer A in 14. তারপরে দেখি বিটা দেখো, পরের প্রেয়ারটা দেখি আলাদা হতে পারে। Then prayer read of prohibition followed by certiorari. Then in at least, my lord, in the latter writ petition, reference should have been made that I filed an earlier writ petition. This is the distinguishing feature. That is why I filed this.
Prayer A is different, my lord, in respect
That
to
should have been
petitions.
pointed out in the second writ petition, subject to your lordship's pleasure. That this is the distinguishing feature. That is why the second writ petition is being filed.
Do you think if we proceed with the second writ petition, it will suffice? It is up to you. I do not know.
Lordship Lord will take up the first writ petition, my lord, because there may not be all other points have been, my lord, covered. With regard to unauthorized construction.
Filing the
Then why
second
the
one?
second?
Yes, my lord. Then, Lord, I am not pressing the second writ application.
I'll leave. I'm in the second.
Case, it is all right.
Well, then second, I'm in item number 8. I need not appear.
You represent the corporation. He doesn't press it. That does not mean that you will not represent the corporation.
No, 14, my lord and friend, is representing the corporation.
14 is there. 18. 18, you are there. You remain there. 14, he is there. And this instruction will 14 is there. So it is all right. একটাই করুন তাহলে, both না। WPA 18548. ঠিক আছে? The matter relates to certain unauthorized constructions at premises number 501, Ho Chi Minh Shoroni, ward number 128, Boro, 16, XIV of the Kolkata Municipal Corporation. Stop. The petitioner alleges that the private respondents have raised unauthorized construction and are carrying on illegal commercial activity from the said construction. Stop. Next. According to the petitioner, a 3-storied building has been raised without obtaining any sanction plan. Stop. Complaint lodged before the corporation is pending consideration. Stop. None represents the private respondents. Stop. Affidavit of service is taken on record. Paragraph. Learned advocate representing the corporation has obtained instruction from the assistant engineer within bracket civil/building and executive engineer within bracket building of the concerned borough, signed on 16th October 2023, which mentions that the persons responsible could not produce any sanction in support of the construction standing at the subject premises. Stop. A case was initiated under section 400 within bracket 1 of the KMC Act 1980, and hearing was conducted by the special officer within bracket building on 31st March 2022 and 12th December 2022. Stop. An order of part demolition and part retention was passed on 17th May 2023. Stop. The higher authority of the corporation decided to place the matter for rehearing, and subsequently rehearing was conducted by the special officer within bracket building on 4th October 2023. Stop. The proceeding is still under process, and no order has been passed yet, and final order has not been passed yet. Stop. On receiving complaint from the petitioner, departmental inspection was carried out. Stop. Next. It appears from the instruction forwarded by the engineers of the corporation that a proceeding to deal with the unauthorized construction is under progress. Stop. Let notice of such hearing be also served upon the petitioner so that the illegalities highlighted in the objection can be placed before the special officer within bracket building who is conducting the hearing. Stop. Next. Paragraph. As regards the allegation of conducting illegal activities, illegal commercial activity at the subject premises, the concerned officer of the Kolkata Municipal Corporation is directed to consider the issue after hearing both the parties and pass reasoned order in accordance with law. Paragraph. A decision with regard to both the issues, that is unauthorized construction and running illegal commercial activity, shall be decided at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Learned advocate for the petitioner is directed to forward a copy of the representation dated 20th June 2023, along with all documents in support of his case, to the executive engineer at the time of communicating the order of the court. Writ petition disposed. The departmental report dated 16th of October 2023 be written with the records. 18 নম্বরটাতে একটা order লিখুন. Learned advocate for the petitioner does not intend to press the writ petition as the relief sought for by the petitioner has already been granted in WPA 18548/23. নম্বরে আলাদা appearance record হবে. Writ petition disposed. Where is your service in 18?
18.
এটা হচ্ছে আলাদা.
Number 12, my lord. One order is passed. Just reach the can appear for the.
হ্যাঁ.
I noticed this just.
আচ্ছা 12 নম্বর আইটেমেতে নানা পিয়াস ফর দি হাওড়া মিউনিসিপাল কর্পোরেশন লেখা ছিল. হ্যাঁ ওই লাইনটা কেটে দিন, ওখানে অ্যাপিয়ারেন্সটা রেকর্ড করে দিন.
In item 302, I am appearing for the bank respondents, being respondents 4, 5, and 6.
I beg to appear, my lord, on behalf of the petitioner, my lord. In this petition, my lord, petitioner has challenged an order award dated 7th June 2022, passed under section 139 of the, my lord, West Bengal Cooperative Societies Act 2006, my lord. My lord, since there is no appealable provision as per the schedule, since the award passed under section 139, so my lord, this writ petition has been preferred.
Page
Well,
number 79.
It starts from page number
76.
Ordering portion is at 79.
76 to 78.
Trigon CCB.
My lord, preliminary, my lord. Preliminary, my lord. I would challenge this award on 3 questions of law, my lord. First,
Yes.
First, my lord, the concerned person who was the arbitrator in deciding the proceeding, he was the chief executive officer at that relevant point of time of the concerned bank. So, a person cannot, my lord, judge his own cause.
Person?
Cannot judge his own cause. Because the
But why did you not raise this issue at the very first stage?
it was not known. It was not known. Subsequently, it has been came from RTI reply, my lord. Because the person who has conducted the arbitration proceeding, he was appointed as the CEO of the chief executive officer of the concerned cooperative bank in 2018. Proceeding was conducted in 2022, and my lord, his charge was handover, my lord. Thereafter, my lord, on, my lord, 30th June 2022. So when he conducted, he should not have taken the proceeding.
1 minute. You have the act with you?
Yes, I have the act. Regarding the writ application against the order of 139.
No, we are just going through 139. Let us see
Yes.
who is the person. Registrar or any person empowered under the rules may, of his own motion or of
Power
his
to direct payment of dues,
of a cooperative
notwithstanding
society
anything contained in chapter
or the
11, the registrar or any person empowered under these rules of his own motion or on the written requisition of a cooperative society or a financing bank for recovery of any sum due by a defaulting member, including a deceased member of a cooperative society, after such inquiry as he may consider necessary or expedient, make an award directing such member or his surety or the successors or a legal heir of the deceased person who may or may not be a member of the cooperative society to make payment of the amount found to be due. So, irrespective of dispute case, the registrar, being the arbitrator, can do that, but subject to disputes. And my lord, here from the impugned order, if my lord takes page 76, plaintiff and defendant, a proceeding under section 139, and in page 78, under signature, he is the RCS and arbitrator of the cooperative arbitrator. And this person, my lord, Devashish Roy, ARCS, was the chief executive officer of the my lord, the bank. So, being the chief executive officer of the bank, he cannot be, he should not
Now,
have taken
this
this.
order award appears to be a detailed one. I think the bank will like to file an affidavit to this.
And my lord,
May I be allowed to make submissions? Firstly, on the ground of maintainability of the writ petition, in view of availability of statutory alternative remedy of review, may not be the statutory remedy of appeal is available here, but statutory alternative remedy of review is very much available. The petitioner could have availed the statutory right under section 148 of this 2006 Act prior to availing this constitutional remedy before your lordship, my lord. And so far as the aspect of violation of natural justice is concerned, my respectful submission, subject to correction before your lordship, would be that natural justice is not a straitjacket formula. A person, if he suffers any real prejudice or any substantial prejudice, may only agitate the point of natural justice. Natural justice does not lie merely on technicalities. The petitioner shall have to satisfy your lordship what real prejudice has been caused to him when the quasi-judicial adjudicating authority proceeded on the basis of material records placed before him, and those documents were not assailed by the petitioner, neither before the statutory adjudicator nor before this honorable court, before your lordship, my lord. So no real prejudice was caused to him. And in this regard, my lord, may I be allowed to rely upon an honorable
file a short affidavit.
Yes, I shall do. I shall do so, my lord.
So it's better you do that.
Yes, my lord.
Please come. The award.
My lord, the question of maintainability may be kept open, my lord.
Yes, yes. Dated 9th.
my lord, it is 7th, my lord.
7th of June,
June.
2022.
My lord, may I submit one more thing, my lord? The petitioner may still avail the statutory alternative remedy of review, since the ARCS as also as the CEO of the bank have in the meantime changed.
Is impugned in the present writ petition. Stuff. The award appears to be a detailed one. Stuff. The
Other points, my lords, I have also challenged with
the,
regards to the disputed facts.
legality of the award has to be decided upon exchange of affidavits. Stuff. Let affidavit in opposition be filed within a period of 4 weeks. Will be
Yes, my lord. 4 weeks.
Reply, if any, within a fortnight thereafter.
3 weeks, my lord.
3 weeks. The matter is directed to appear in the list immediately after completion of affidavits. Stop. Next. The issue of maintainability of the writ petition as raised by the respondent bank is kept open to be decided at the time of final hearing of the writ petition. Service taken on record.
But in the meantime, my lord,
So this service was there already on
already
record.
there, but previous direction was there to communicate some order and notice to them since they are. My lord, in the meantime, my lord, I would beseech my lord interim order.
I am not passing any interim order.
I'm grateful
As
to your
your
lordship.
lordship.
Next one, please.
But I'm appearing on behalf of the petitioner, my lord. This is my affidavit was service.
What is your prayer?
My lord, petitioner appeared in the election process conducted by the cooperative. Sorry, my lord. West Bengal Cooperative Service Commission. Petitioner applied for the post of the clerical post and appeared in the examination Before that, Cooperative Service Commission issued admit card to the petitioner. Petitioner appeared and appeared in the said written examination, and thereafter petitioner not received any letter for interview in this matter. The
Yes.
the petitioner petitioner is challenged this the selection process. The selection total candidate was 92, and panel was disclosed of the number 87. So petitioner is successfully appeared in the examination, and
How do you know that he was successful?
the petitioner's confidence, my lord.
The confidence will not do. You have to show. Did you collect information?
No, but
Then
the petitioner is praying for submit the answer script of the examination.
production of answer scripts.
Yes, my lord.
Why? Where is your application under the RTI Act?
No, but I have made no application.
Then why will the court pass such an order? When did the examination take place? 2020, the advertisement was published.
Admission was published on 10th January
When
2020.
did the selection process conclude? January 2022.
Advertisement published on, my lord, sorry.
Following and recommended by the commission.
On the advertisement number 2, 2020.
January 2022, the list of recommended candidates was published.
Yes, my lord. Petitioner appeared in the examination on appeared in the examination on
For appointment to
Annex P2, my lord.
On basis result, the online examination held on another interview of this. Did your candidate appear for interview?
No, my lord,
No.
no interview later received.
The petitioner participated in a recruitment process initiated by the West Bengal Cooperative Service Commission video advertisement number 02/2021. Stop. Next. The petitioner took part in the written examination. What written examination was conducted?
Yes, my lord.
Written examination.
On 28th February
On
2021.
28th of February 2021. But his name was not included in the list of candidates selected for, not selected, eligible for taking part in the interview, eligible for appearing in the interview conducted between 28th September 2021 to 18th of October 2021. Stop. Next. It appears that by notification dated 10th January 2022, the list of successful candidates whose names were recommended by the commission for appointment to the various posts
— 87% out of 92.
Stop. The petitioner paragraph, the petitioner submits that only names of 87 candidates were published, whereas there were vacancies for 92 posts. Stop. The petitioner contends that he is confident that he performed very well in the written examination and he ought to have been permitted to appear in the interview. Stop. Next. Upon perusal of the materials on record and upon hearing the submission made on behalf of the petitioner, it appears that the interview in question was held between 28th September 21 and 18th October 2021. Stop. The petitioner being ineligible to participate in the interview was did not challenge the result of the written examination. Stop. He neither questioned the action on the part of the Service Commission in not permitting him to participate in the interview. Stop. The final list of successful candidates stood published on 10th January 2022. Stop. The petitioner has filed this writ petition on 27th of July 2022. That is long after the entire selection process was over. Stop. Paragraph. It appears that being unsuccessful in the written examination, the petitioner did not approach the court in proper time. Stop. Filing the writ petition after such a long delay of publication of the final list of selected candidates, comma, the prayer of the petitioner for production of the answer scripts, and that too in the absence of a formal prayer being made under the Right to Information Act, 2005, cannot be accepted. The writ petition fails and is hereby dismissed.
Yeah.
Yes, please give your appearance.
Agree with service.
But for election commission, election matters. And I'm appearing for the petition, my lord.
When did the term expire?
In 2020, my lord.
20?
May I hand over blood
You have a copy? Please give. Very well. Same order will be passed. একটা চেঞ্জ আছে ডেট ডেটটা আমি চেঞ্জ করে দিচ্ছি
Mala 305 and 306, Mala, I'm praying for Mala time, Mala, because Mala, the advocate and record did not come to court and brief is not in my hand, Mala.
On the prayer of the learned advocate representing the petitioner, comma, the writ petition stands adjourned. Now, let the matter appear in the combined monthly list.
No, Mala, combined one is Mala, only for Mala brief is not in my hand, Mala, because only I am the not pay any day, Mala. Only for Mala brief is not in my hand, Mala. Only not today, Mala, because.
Let the matter stand adjourned for this week.
Yes, Mala.
Not for the next lordship.
24th, you will not be there. Then 1st December,
Yes.
Friday.
Yes. And this 6. Okay. I'm this.
Lord, I appear on behalf of the.
And for the petitioner led by Mr. Su.
You are for the petitioner?
Yes, ma'am.
Yes. What is the matter about?
On the last occasion, my lord, your lordship passed an order regarding mental ability of the
Benefit is state.
Now a point was taken whether benefit against benefit a writ petition can lie. Now I have already, my lord, on last occasion, the judgment which I have handed over, your lordship, today, that court has already discussed by the coordinate bench.
Yes.
Your lordship, please stay away, come. Reference দিচ্ছি না কত রিপোর্টেড কত ছিল page number 13 from the first paragraph. Citation টা কোথায় গেল?
Is it a reported judgment?
No, it is an unreported judgment.
Please give a copy.
My,
Then please give a copy.
and I have no spare copy.
At least share one copy for the time being.
Paragraph, your lordship, please have a look, page 13
Page 13, yes.
from the top.
Right.
Judgment আছে তো সেট করা বার করো না
copy আছে।
বার করো না 4962 অর্ডারের কপিটা কত অনলাইন করলে হবে
What is the issue over here in the present writ petition?
in the present writ petition, in our writ petition, the matter relating to died in harness appointment.
This is also appointment.
Appointment on died in harness.
Died in
Under
harness.
compassionate gown, that
Died
was
in harness, where was the employee working? Benfed.
benefit.
And does the Benfed have any scheme for providing
That they have-
compassionate appointment?
The government order 251, that was relied
Who has relied and where it has been relied upon?
while passing the impugned order, which is
Where
under
is the impugned order?
page 143.
143.
251, the EMP 251.
Where is this 251?
Copy একটা copy. It was already handed over on last occasion. Text. It is in mark, if you lordship could find out.
Yes, it is here. But doesn't 251 apply to only government employees?
Yes.
State does not means
Definition
government.
3. F.
State does not means government, isn't it?
Right.
Does it mean?
Right.
It does not mean government.
Right.
So how will 251 apply
Was
over
relied
here?
on.
Does the benefit have any other scheme relating to
For my
compassionate?
knowledge, there is no other scheme.
How
For
do
my
you
knowledge, that
seek?
benefit can say.
How do you seek appointment in that case if there is no scheme?
Already. Well, they have already appointment to others.
They have given appointment to others.
Others. Three persons are already appointed, so per my knowledge.
So you are relying upon the principle of negative equality.
No, not negative.
Then show me something that there is a scheme pursuant to which this appointment can be made.
But that at best, my lord, the benefit can say, my lord, this.
But is it not for the petitioner to come forward with a clear case that this is the law and I apply this law, relying on this law, appointment is to be given?
Right.
It is not there.
No. Suddenly. Definitely. It is my also due. But the benefit is, my lord, considering or dealing the 251. Benefit in all matters.
Are you representing benefit?
Yes, Lord.
Yes.
Lord, before I start, I tell your lordship two things. One is I've gone through the entire petition. I feel that certain questions of fact are involved. Without any affidavit, whether your lordship will go into that fact, Lord, it's a question for your lordship to consider. Because I feel not given a chance to file affidavits. All the parties may bring in documents as also, because for example, 251, they have not annexed it. For your lordship's assistance, that will be necessary.
But tell me one thing, the issue is appointment on compassionate ground. This, according to the petitioner, is such.
Yes, that is the issue, only issue. And our defense is, I tell you, indicate to your lordship. Number one, it has been consistently held as law by the Supreme Court. The two things are essential for compassionate appointment. It does not come as a course. One is sudden financial crisis, and two is immediate financial crisis. Sudden and immediate. Financial crisis must be there, and it must be immediate. That means today a person dies. After 2 years, no one can claim, well, look, I had a job, that job is gone. Therefore, give me compassionate appointment.
But does your does the authority have any scheme?
No.
Assuming the application is made in proper time, and assuming there is a financial crisis, in the
Even
absence
then,
of a scheme,
yes,
can this be given?
No, certainly not, because I am instructed that there are already 41 such applications, and his number is 42 applications. And his number is 40. So if I have to give, so what fault do I find with the earlier persons in
So the writ petition can be dismissed. I was thinking of dismissing. I am expressing
feel
my
that-
mind that in the absence of a scheme, it cannot be done.
That's it.
So what is the use of filing affidavit and then keeping the matter
if-
pending? Because he will be under a legitimate expectation that the appointment may come at some point of time. Some order may be passed somewhere. But if there is no scheme at all, why keep the writ petition pending?
Father died in 2011, 15th August 2000.
More so the reason not to pass any order in this matter.
That's what I say.
So it's over.
12 years have passed.
Why?
No financial stringency.
For register, we are appearing. On the last occasion,
For the registrar? Yes.
we took the point of maintainability.
Yes, maintainability, I understand.
And Lord, it is decided it is not, because the judgment what I will refer to by my letter. Here, Lord, I find that Lord, this issue was not raised.
This issue was not raised?
Not discussed at all.
No, it is discussed.
Page 13, page
No.
13, sir.
Yes, because the scheme Milord under section 134, chapter 13A and section 134, where it is given the autonomy. It is having the autonomy among they can Milord man the entire situation of in their own way. Here the question of violation of fundamental right or accrued right or any illegality under this writ proceeding does not come at all. Now the question is, if it is doesn't lie, then all these questions may not come. Now the secondary thing is coming that yes, there is no scheme or there is no scope, there are other. It is immaterial, because when this particular body is having its autonomy and they will frame their own principle, whether they will accommodate, they will give appointment or not, that cannot be challenged in writ proceeding. It's a case of benefit, they have their own decision. They have their own board and they have decided it. And they are coming clearly under section 134C and chapter 13. If Lordship wants, kindly see this. And Milord, it is also supported by Milord the Supreme Court judgments. Therefore, the secondary point which is discussed here, Milord, that will come later. Because if it is not maintainable, then question does not come. And in this
did you take into consideration the judgment that is shown today?
Yes, Milord, 134C was not
Muhammad,
I have not found.
134 was not taken into consideration, but benefit it was taken into consideration. Whether this can be treated to be as a state or not.
Yes, but benefit is enjoying the autonomy, the status under section 34, chapter 13. Milord, if they have their own Milord autonomy, which override other provisions of law, then Milord question this consideration perhaps may not be taken into consideration. Also, kindly come to this. I have not seen.
No, but then without going into all these things, please come.
That's the Milord, look, I have gone through. I have not seen. That's chapter 130. Okay.
Maybe the provisions of the Cooperative Society Act was not taken into consideration, but then at the same time, the authority of benefit was taken to be as state under Article 12.
I take this issue very specifically, Lordship.
Well, please come.
That issue discussed and decided.
In some matter, we will decide, not here. This is
Madam,
not a
I'm
case
for the
where
state
this
respondents.
is to be decided.
Madam, I'm only on behalf of state respondents.
Yes. The communication dated. Now, the decision communicated by the general manager within bracket administration. Wide communication dated 30th June 2022. Oh, general manager administration, comma, the West Bengal State Cooperative Marketing Federation Limited. Date and such and such. Intimating the petitioner that appointment on compassionate ground cannot be given in terms of the notification number 251-EMP dated 3rd December 2013 is impugned in the present writ petition. Stop. Next. Paragraph. The father of the petitioner was an employee of all caps Benfed. Stop. He died in harness. On 15th August 2011. Stop. An application seeking compassionate appointment was filed by the widow on 14th September 2011. Acha. The the rejection of the prayer for compassionate appointment was communicated to the petitioner in June 2022. Stop. Next. The petitioner submits that there are several similarly situated candidates who have been provided employment on compassionate ground in Benfed. Stop. It has been submitted that the notification number 251 relied upon by the respondent authority will not be applicable in the present case. Stop. Next paragraph. The respondents have raised an issue with regard to the maintainability of the writ petition. Stop. It has been submitted that a writ will not lie against Benfed, as the same cannot be treated to be state within quotes under Article 12 of the Constitution of India. Stop. It has been submitted that Benfed is an autonomous body guided by its own rules. Stop. Next. On a query from the court. Now, query আগে লিখুন. The learned in response to the aforesaid submission with regard to the non-maintainability of the writ petition before this court, the petitioner has relied upon the judgment dated 26th June 2012, 28th of June 2012, and 3rd July 2012 and 17th July 2012. Passed by a coordinate bench of this court in WP 14960 W of 2005 with WP 22091 W of 2005 within bracket Muhammad Parirok Hossain Mananta dekhe neben versus State of West Bengal and others, wherein the court was of the opinion that Benfed opinion that nexus of Benfed with the state is palpable from the fact that in the absence of a managing director, comma, it is the principal secretary, comma, Department of Cooperation, comma, Government of West Bengal, who is holding charge of running the organization. Stop. The court was pleased to entertain the writ petition filed against Benfed and was further pleased to pass necessary order therein. Stop. Next paragraph. On a query from the court, comma, the learned advocate representing the petitioner has failed to produce or rely upon any scheme permitting appointment on compassionate ground by Benfed. Stop. Next. In the absence of a proper scheme for providing appointment on compassionate ground, comma, the prayer of the petitioner seeking appointment on compassionate ground cannot be entertained. Stop. The petitioner has also failed to produce any document to show that the notification number 251 EMP would be applicable in the facts and circumstances of the present case. Stop. Memo number, not memo, notification number 251 EMP has been produced in court. It appears therefrom that the same is applicable in respect of the dependent family member of a government employee. Stop. Government employee has been defined in the said notification, which means a government employee appointed on regular basis and not the one working on daily wage or casual or apprentice or ad hoc or contract or re-employment basis. Stop. The father of the petitioner was not a government employee. Stop. He was an employee of benefit, which may fall within the definition of state within quotes, but certainly cannot be treated to be a government employee. Stop. Next. In view of the above, the prayer of the petitioner seeking compassionate appointment cannot be accepted. The writ petition fails and is hereby dismissed.
Wait, my lord, I am the petitioner.
308.
300, I am the petitioner.
Yes. What is the matter?
My lord, my lord, at first,
for the bank.
my lord, at first I'm praying leave to file one supplementary affidavit in regard to maintainability, which was raised in earlier occasion. My lord,
Why supplementary affidavit with regard to maintainability? Maintainability is a point of law.
Point of law.
Yes.
I have enclosed certain documents here.
Documents in support of what?
In support that actually what happened in this matter, bank was initially run by the board of directors, and thereafter the board dissolved and subsequently administrator appointed. Now this matter relates to my lord disciplinary proceedings. Now I have been dismissed, and thereafter I have preferred an appeal, statutory appeal before the special officer. Now it is lying pending. It is only my grievance at this stage.
What is your grievance? The appeal to be disposed of?
Appeal to be disposed of. Now, my lord, in earlier occasion, the learned advocate for the state government, my lord, raised an objection that in regard to maintainability. My lord, according to him, this writ application is not maintainable since it is cooperative bank. And this is the entire scenario. My lord, as such, I am praying leave to file this supplementary affidavit by annexing one document, one or two document, and an earlier occasion also my learned friend submitted one judgment passed by the coordinate bench, learned coordinate bench, my lord. In this matter, my lord, in this situation, my lord, this judgment is not applicable in my case, since the entire the bank is at present running under the supervision and control of the special officer, who is the holding the post of registrar of cooperative society.
And the registrar of cooperative societies is the appellate authority.
Yes, he is now actually in the name of in the other name of special officer. Lordship, kindly see this memorandum. And in that regard, my lord, I am praying leave to submit, my lord, one judgment passed by the division bench of this honorable court, and I am inviting your lordship to come at paragraph 10 of that judgment. Just have to din na. জাজমেন্টটা পরে রাখুন, আগে ওই সার্কুলার। হ্যাঁ ওইটা
complete autonomy in all financial inter petition is such person. Please show me the order which was carried in appeal.
Yes, that is the order of dismissal, my lord.
Yes.
It is lying in the file.
It was passed by the bank.
Passed by the bank. No, passed by the special officer. Actually, board of directors are not there.
Special officer passed the order of dismissal.
Managing director. Managing director.
Yes, so I want to see the order of the managing director, the bank.
Dismissal ordered passed on 30th December 2022. Order of dismissal 408 to 410.
Thirtieth of December 2022, managing director of the bank passed this order. You have preferred an appeal to the special officer. Right, and the special officer is the registrar of the cooperative societies. Your present, the relief that you are presently seeking is a direction for conclusion of the appeal.
Let them pass any order. I know what will be the fate.
All right.
Let them communicate any reply, my lord. At least one reply.
Very well.
My appeal is not maintainable. My appeal is rejected. I don't mind.
I get it.
Only one communication I am paying.
Registrar.
But in fact, the special officer was active in the order of this. Special officer
Yes.
Any officers will act as special officer, not in absence of the board. Board either has been dissolved or not in a binding or observing situation. Officer has been special. On the special officer will act in the absence of the board.
But the court cannot ignore the fact that the special officer is the registrar of cooperative societies. So even in that case, will the writ not lie?
No, because here you are absolutely credit society which is covered under Constitution 34C, 34A.
Who is the appellate authority? The special officer is the appellate authority.
Board is the appellate authority.
No, board is not there.
Was not there.
So right now it is a special officer.
No, special officer passed the order.
No, the managing director has passed the order.
No, it should be no, I'm sorry, it should be the chairman.
Chairman
the
of-
order managing director, the chairman is the appellate body.
Chairman of the bank.
Right.
But is the chairman there?
No, I don't think so.
And they have their own service rules, lordship. That is
The board is also not functional, and the special officer, according to the petitioner, is the registrar of cooperative societies.
that will not apply at all because
Well, it can be any officer.
that status is not applicable here. It's a mayor officer in the he's holding the power of special officer in absence of the board.
I get it.
Not will not register at all.
I get it. Even then,
And they have their own service rule, that will be followed. That is to be followed by them. The special officer will follow the service rule of the
what does the service rule say? That how long is the period for conclusion of the appeal?
May I address your lordship on that? Your lordship has been pleased to, my lord, note the date of the order of dismissal, that is
Yes.
30th of December 2022 at page 408.
Yes.
My lord, my learned friend's client, my lord, prefers the appeal on 17th of March 2023 that your lordship has found from page 411. Now, please have a look to the rules, the relevant rule, rule 53 at page 38 of the writ petition.
Yes, 30 days. I admit it. Yes. But at the same time, my lord,
Wow. Let him make submission. Please don't interrupt.
Page 38, the last 4 lines.
Yes.
Without restricting the power and the authorities specifically conferred by the board of directors on the chairman, the managing director, the manager, and an assistant manager, and accepting an order passed by any one of them on matters relating to day-to-day administration and routine affairs of the bank, an appeal shall lie from an order of the authority shown in column 1 to the authority shown in column 2 and within the period shown in column 3. But in our case, serial number 3 applies.
Yes.
Managing director is the authority passing the order, chairman is the appellate body. C, or the third is period of limitation, same as above, which means within 30 days from the date of the order.
Yes.
Now, this is, my lord, the scheme of the rule. But my learned friend's client admits, I found that at one place, that it is beyond the period of limitation. Therefore, my lord, your lordship kindly consider, my lord, that whether the innocuous prayer, my lord, made in the writ petition, my lord, at page 25 can be granted or not. Please have a look to the prayers at page 25, which my learned friend says. Written the nature of mandamus commanding so and so to consider the appeal which was filed by the petitioner on 17th March under the provisions of Regulation 53 and to dispose the appeal by a reasoned order forthwith. But my very humble submission, but once, my lord, the 30 days period expires, but the remedy becomes barred. Number 1.
Why will not one line be made known to the petitioner that remedy barred, time barred appeal, finish it off?
But that would be my
I shall be happy. I shall be happy.
My second submission is, my lord, that if the remedy is barred, well, please consider this, my lord, as a proposition of law. My lord, is there any obligation on my part
to communicate?
Or whether, my lord, the petitioner can approach a writ court and revive a barred remedy. Now, this would, my lord, amount to reviving a barred remedy by saying that you communicate whatever is the fate of the appeal, or that the appeal cannot be considered.
So where is the revival? The appeal was not even born.
Yes. Yes. Therefore, it is
because it conceived after the period of limitation expired.
Right.
So it's stillborn type of thing. So by virtue of this order, can it be revived?
No.
It cannot be. So no one is reviving. But then
I did not make myself clear. But on and from the 31st day, my lord, the right of appeal expired, exhausted. Therefore, my learned friend's client did not have any right to even present the appeal on the 31st day and thereafter. Now, please consider, my lord, if he doesn't have a right on from the 31st day, the remedy which was available to him up to the 30th day becomes a barred remedy, because up to 30th day he had a vested right of appeal. Now, this vested right of appeal expires on the 31st day. Therefore, my lord, on and from the 31st day, my lord, the vested right or the vested remedy becomes barred by the law itself, unless there is some provision to condone the delay.
Limitation Act possibly will not apply.
Will not apply. Therefore, the second question comes. The second question would come is that if somebody approaches the appellate body after expiry of the statutory period and thereafter approaches the writ court, whether the writ court can also extend that time. Your lordships, no, my lord, I need not, my lord, cite judgment on that, my lord. Writ court cannot extend the time unless there is power in the rule itself.
Suppose a direction is passed upon the appellate authority to communicate the fate of the appeal. Does that imply that the court is reviving the appeal? The court is giving a fresh lease of life to the appeal? The court is not.
May I put it in this way, my lord? There is a division bench judgment of our High Court by Justice Bhaskar Bhattacharya, though Milord on a different context. That was in the context of these Milord hypothecation cases and all that, where Milord people fail to repay the loan installments, etc. Thereafter, Milord, these finance companies, Milord, they catch the or Milord seize the vehicle, and then the proceedings are started. But there, Milord, the division bench has held that if the remedy is barred, you cannot approach the writ court even. The remedy is available when? That he has approached the writ court within this 30 days, say without preferring an appeal. And if somebody points out that his remedy was by way of an appeal, he should have gone before the appellate body within 30 days, but he has not gone to the appellate body and directly come before the writ court within 30 days, then Milord, the writ court has the power to extend the time because he was pursuing a remedy before a wrong forum within the period of limitation provided by the statute or the rules. In those situations, Milord, the writ court can, Milord, revive that right. Okay, you have approached the court on, say, on the 20th day. The writ court can relegate the parties to the appellate body.
In that event, what happens? The appeal, maybe a time-barred appeal, was filed. And there is no, and the person concerned is not intimated with regard to the fate of the appeal. What happens?
Yes. But to that, Milord, my very respectful response would be that, Milord, if somebody has chosen not to come within the period of limitation, because my obligation is to inform the fate of the appeal upon consideration if somebody approaches me within the period of limitation. Now, please consider it from a different angle, that if somebody comes to me beyond the period of limitation, but possibly, Milord, on a legal advice, Milord, possibly, Milord, the appeal would not have been accepted. Anyway, they have
returned. It could have been returned on the very first day, not accepted, time barred, finished.
Yes.
But then you sit tight over the matter. You do not
Milord,
intimate him.
please consider, Milord, this, Milord.
So you say that it is your right. It was well within your right not to communicate the fate of the appeal since it was filed beyond the period of limitation. This is what you say.
Well, it's no appeal.
It's no appeal.
It's no appeal.
One line communication. Do you think it will revive the appeal? I do not think so. I do not find how.
I was trying to impress upon your Lordship, Milord, in a reverse manner. The reverse argument that I wish to make before your Lordship is, Milord, whether, Milord, any authority has an obligation to speak, duty to speak, as we know in administrative law, whether any authority has a duty to speak in respect of a barred remedy. Milord, your Lordships have always held that in the administrative law, the authorities have a duty to speak. Now, does that duty to speak continue in a case where there is a period of limitation fixed? But take an example. I can give you, Lordship, a different example. But I apply for an excise license pursuant to an advertisement. Then also, Milord, if the period expires, say 1 month time is there to apply for it, I apply on the 31st day. Is there any obligation on the part of the authority to say that, sorry, sir, if the period of 30 days has expired, so I return your application? The authority will simply not consider it.
What you submitted, the example cited, is with regard to a public advertisement. There may be many applications. If the period of limitation is over, it may be that the authority do not revert. But this is a case where the person concerned was in service he was dismissed or any punishment what has been imposed, he preferred an appeal beyond the period of limitation. After all, he was your employee. Will you not intimate that, look here, your appeal cannot be entertained because it is time barred?
Yes.
One line. Will it be such
Yes.
that there is a right not to speak up? There is no requirement of communicating or anything of that sort.
But since your lordship has drawn the analogy of a service matter, take another example in the service jurisprudence itself. There are 10 people are eligible for promotion, one is selected. Does the other 9 have a right to be communicated the reasons for not selecting them? The answer, as your lordships have held, there is no requirement. Similarly, over here, if something which has, as your lordship has been pleased to use the expression, is a stillborn appeal. Now, in a stillborn appeal, do I have an obligation to say that no, your appeal is stillborn? Because he knows that the appeal, in fact, my lord, kindly have a look at one thing, one paragraph somewhere I found. He himself admits that
Yes, I admitted.
yes, that there is
certain delay, and I have disclosed my ground. Why I could not approach in time?
No, but then is there any provision to condone the delay?
No.
Then what remains? Why do you want an answer from them? Why will the court spend so much of time?
Malad, one thing. After accepting the appeal,
where is the acceptance? You have filed it. Where is the acceptance?
They have received the appeal.
Yes.
And thereafter,
there is a filing section. You go file it. They give a stamp. Does this means that it has been accepted and it has to be replied?
They could refuse it.
Assuming they have accepted it. Assuming. But then you admit that it is a time barred appeal. What remains? How can you revive your claim?
Yes. Page, the first page 411.
In first paragraph, I have pointed out that due to...
So you know that your appeal is dead. It was never born. What remains? What relief can you expect? Either from the authority or from the court. What exactly are you trying to drive at?
My expectation, at least
satisfaction. I'll record that it is time barred and it was never born.
My expectation is that let them say.
What they will say? Why will they say? The law says.
Shall not consider. It is
no question of consideration.
It is the courtesy, my lord. When I submit one appeal for necessary consideration.
There may be several employees like you who may have filed appeal beyond the period of limitation, and the authority will go on replying.
No, my lord. I have no such knowledge.
What exactly are you trying to drive at? You do not have any merit. The Limitation Act does not apply. Can you show me any provision where the period of limitation? No such provision. What remains? You have filed so many pages, writ petition, servicing copy. You have served copies upon the all the parties, and see the amount of trees that you have consumed at the time of preparation of these documents. Now, whoever it is, pocket can be filled up, but the trees are gone.
No, I am not on that. My lord, the lordship raised this question. I made such reply.
Yes.
My lord, what I am saying, my lord, then lordship, if your lordship dismiss my application, I don't mind.
Very well.
But at the same time, my lord, lordship kindly held the writ application is maintained.
The court will not hold anything. Please come.
My writ application is maintainable. I know the fate of this case. Actually, time but one judgment, Supreme Court judgment is there. The court cannot stress the period of limitation.
So you are submitting against you.
My lord, I know it, but I prefer this appeal.
Why? You've got a lot of money and you want to spend it on this?
My lord, I'm.
The petitioner was an employee of the West Bengal State Cooperative Bank Limited. A disciplinary proceeding was initiated against him and
order
he was dismissed
online order
by the managing director of the bank by an order dated 30th December 2022. Stop. The time period within which an appeal could have been preferred against the order passed by the managing director is 30 days. Stop. An appeal was preferred by the petitioner long after the statutory period of limitation. That is on 17th March 2023. Stop. Next. The appellate authority neither considered the appeal nor intimated or communicated the petitioner the fate of the appeal. Stop. Next. On account of the non-action and or inaction on the part of the appellate authority to communicate the fate of the appeal, the present writ petition has been filed. Stop. The respondents raise an issue with regard to the maintainability of the writ petition. Stop. It has been submitted that the bank, being an autonomous body, it does not fall under the definition within quotes state, and accordingly the writ petition will not be maintainable. Stop. Next. Decisions have been relied upon by both parties in support of their respective stand. Stop. Next. On a perusal of the documents placed before this court and upon hearing the submissions made on behalf of both the parties, it appears that the appeal in question was filed at a belated stage. Stop. The principle of the Limitations Act will not apply in the instant case. Stop. Next. The learned advocate for the petitioner has failed to produce any provision of law permitting extension of time for consideration of the appeal. Stop. Next. No provision has either been shown to the court relying upon which the delay in filing the appeal may be condoned. Stop. Next. In view of the above, the prayer of the petitioner seeking for a direction upon the appellate authority to communicate the fate of the appeal cannot be entertained. Stop. Next. The appeal could not have been said to be born at all. Stop. The writ petition fails and is hereby dismissed.
I have prepared the respondent number 2 and 3.
Respondent number 12, petitioner.
2 and 3, my lord.
2 and 3, petitioner.
I am for the petition.
Yes.
My lord, in this matter, my lord, I am challenging a decision of the cooperative bank in respect of suspension, my lord, which has been challenged before your lordships. The last occasion, your lordships, regarding the maintainability of writ petition, my lord, I supplied a copy of the But I don't find it in any reporting, but South Indian Bank, all
South
the
Indian
learned
Bank
friends.
Limited.
Yes, madam.
Naveen Matthew Philip.
The
Yes.
paragraph 16 of that.
Paragraph 16.
Paragraph 16 of the last part of that paragraph. Where the repetition can lie, my lord. My lord, your lordship kindly come to
Yes.
27. There is a
27.
got
The
it.
principles of law.
Yes, my lord.
Yes.
The power under Article 226 of the Constitution of India to issue writs can be exercised not only for enforcement of fundamental rights but for any other purpose as well. The High Court has the discretion not to entertain a writ petition. One of the restrictions placed on the power of the High Court is where an effective alternative remedy is available to the aggrieved person. Exceptions to the rule of a alternative remedy arise where the writ petition has been filed for enforcement of a fundamental right protected by Part 3 of the Constitution. There has been a violation of the principle of natural justice. The order or procedure are wholly without jurisdiction. And the virus of a legislation is challenged. 27(3) in respect of issue, here I have come for principle of natural justice because the suspension order was issued without giving me any so cause notice, which is prior to the suspension. That is, your lordship, if your lordship kindly goes Rule 106(16), where the suspension has been of the cooperative society rules 2006.
Rules of the Act.
Rules.
106.
Act, my lord, there is nothing, my lord, in the Act.
106.
Lordship 16.
Suspension.
Yes, ma'am. An employee of a cooperative society whose conduct requires investigation on a charge or misconduct enumerated in the clause A of paragraph 14 may be placed under suspension pending inquiry. If the opinion of the disciplinary, attendance of such employee on duty during the period of investigation into such charge is likely to vitiate the proceeding. An employee of a cooperative society may be placed under suspension or there is no criminal case, so B is not applicable. An employee who has been suspended shall not to absent himself from his ordinary place of residence during the period. During the period of suspension, an employee shall be entered. A, that is the employee of cooperative society whose conduct requires investigation on a charge or misconduct. There is no charge against me. Your lordship kindly go through the letter of suspension. What they says in that suspension letter.
Yes. Page 14, my lord.
Lecture, please. Whereas on a visit to the record room of the Panchkura branch office of the bank, the manager of the branch noticed that one loan file was lying on the floor, and on the scrutiny of it, he found that the scrutiny documents are missing from inside it. Whereas from a video footage dated 16/9/22 recorded that the closed circuit camera installed at the Panchkura branch office at the bank, it transpired that the Somu Samanto, a grade 3 employee of the bank, entered the record room of the branch office unauthorizedly, removed the security documents, original deed of mortgage land from the file number 10. Here I pause for some times. But in the CCTV camera, they can see that I can enter. But even they can see that the file number 10765 have been taken away. Can it be possible on a CCTV footage? For these reasons, they have already stated that whereas on chasing by the manager of the next paragraph, said Somo Samanto confessed on 39/2020 in writing that he stole the said security documents from the concerned loan file kept in the record room on 16/9/22. My lord, I said that I have never wrote such letter. And on that point, my lord, suspension has been made against me, but no opportunity of giving hearing to it. Now, my lord, they have, my lord,
Now, this is in October 22. Thereafter, what happened?
thereafter, my lord, the disciplinary proceeding has been started. So what happens, my lord, now practically the matter
This
has been.
became infractuous. Then what remains?
But the question of, my lord, the maintainability point, my lord, at that time, since it was, my lord, the my lord, kept, that is to be.
And see, you have filed the writ petition on 18th of July 2023. This order of suspension is of October
Till
2022.
that period, my lord, no disciplinary proceeding has been started. That's why, my lord,
But even then, you have applied to this court after such a long delay.
that might,
Why will the
that
court
might,
enter?
that might be. But question is, my lord, that from that period, 16, after my filing of this writ petition, they have started the disciplinary proceeding.
Now you get a chance. Are you getting a suspension allowance?
And probably, my lord, no charge copy, nothing has been given to me.
My lord,
Suspension allowance is paid.
my lord, one thing more, my lord.
You contest the disciplinary proceeding and take steps. Please come. The petitioner is aggrieved by the suspension order passed by the Chief Executive Officer dated 14th October 2022. Stop. Specific submission of the petitioner is that no opportunity was granted to the petitioner. No opportunity of hearing was granted to the petitioner prior to issuance of the order of suspension.
Definitely. My lord, one thing, my lord, the charge has been supplied to them on 26 June 2023. And by the same has been posted to the speed post consignment, and that has been received by the parties. That has not been enforced in the writ petition. Suppression of material facts, my lord.
Stop. Next.
It
It has been submitted by the learned advocate representing the petitioner that there has been violation of the principle of natural justice, and accordingly, the writ petition was maintainable, and necessary order is required to be passed. Stop. In the course of argument, it has been submitted by the learned advocate representing the petitioner that presently a regular disciplinary proceeding has been initiated against the petitioner. Stop. Next. Learned advocate representing the bank submits upon instruction that charge was framed and a copy of the charges was forwarded to the petitioner by a communication dated 26th of June 2023.
My lord.
And the petitioner is contesting the disciplinary proceeding. Stop. Next.
July.
It appears from the submission made on behalf of the parties that the impugned order of suspension is dated 14th October 2022, and the present writ petition has been filed on 18th of July 2023. Stop. In the meantime, charges were framed and copies applied to the delinquent employee in June 2023, that is prior to filing of the writ petition.
My lord.
Stop. Next. The 30th June.
30th June.
The conduct of the petitioner in approaching the court after such a long delay. Long delay cannot be accepted. Stop. The petitioner has already taken steps in the disciplinary proceeding, and it will be open for the petitioner to raise all issues in the pending disciplinary proceeding. Stop. No order is required to be passed in the instant writ petition. The writ petition fails and is hereby dismissed.
Developed.
Is there any regular matter, election matter, Mr. Nayak? Are you aware?
Yes, my lord, election matter regarding
Which one?
320. 320.
320?
Yes.
320, only one? এই 320 প্রদীপ একটু দেখি না 320.
Yes, my lord.
For the petition. When did the term expire?
The term expired on 10th of May 2020.
উত্তম কুমার আদক?
Yes, Lordship. Lordship, the affidavit of
Usual order আছে না election?
My lord, what happened? My lord, what happened? As per your lordship's earlier direction in the case of Tomulu Ghatal Central Cooperative Bank to hold the election of those primary cooperative society, SPS society, 76 societies are there. My lord, within that, this petition was filed before that. My lord, within this, after my lord's order, they have communicated, they have informed, Election Commission has issued the notice for holding the election, and the range officer has returning officer has also issued informal notice. Because of this, even then, that order was issued, my lord.
When is the date of the election?
My lord, no election, nothing has been, but just informal notice has been issued as your lordship's direction was there. Kindly see.
Is Mr. Nayak aware of this communication?
Informal notice.
Are you aware of this communication?
Your lordship, and that petition was in the second paragraph, my lord. Kindly see.
Oh, it's all right. Regular order যেটা আমাদের আছে না, usual order in election matters. The term expired on 10th May 2020.
Yes, sir.
Within 6 months?
My lord, let the election will be held within 3 months, because the delegate election.
Number 3.
No delegate election.
At the earliest, positively within 6 months.
My lord, because my lord, 900 members are there, 951.
Any other matter, Mr. Nayak, if the petitioner is there? 317, is the petitioner there?
Yeah.
No.
17, my lord.
You are there? Election matter?
Election matter.
When did the term expire?
16th June 2022.
It is item number 17.
370. 317.
Sumita Mojumdar?
Yes, madam. Well, this is the affidavit of term.
Tulolit Babu? 317. Code expired on 16th of June 2022. Three. এটাও 3. If the petitioner is there, then only it can be taken up. Ainin, Pradeep. Disposed. 319, is the petitioner there? No.
19.
No, then nothing doing.